One RSA, there is a money suit and lordship. Both the cases are decided in favor of the plaintiff lordship. In regular second appeal, stay was granted without direction for depositing. I have filed one IA for modification. Permit tomorrow.
No,
Then immediately after
mention it after vacation.
after
Not
the
now.
opening. Obliged.
34 lordship.
Hmm.
In this case, I filed IA for early hearing lordship. I filed IA for early hearing lordship. So as per my client instruction lordship, I do not want to place the IA lordship.
Huh?
I do not want to place the IA lordship.
Early hearing,
Yeah,
34.
34.
A. Sharma,
Yes, sir.
you are for the respondent.
I am.
Why?
Client do not want the early hearing lordship. My client. That is my instruction.
Mr. A. Sharma, the learned counsel appearing on behalf of the respondent number 1 to 6, submits that he has instructions to withdraw the interlocutory application being IA Civil 145885/2024, which was filed for early hearing. In that view of the matter, the instant application stands dismissed. It was IA 1485 होते, not in RSA. Okay?
Obliged. For tomorrow, my lord, one IA of delay for 2 days, my lord.
Tomorrow?
Tomorrow.
Absolutely no, after vacation.
Please, Your Lordship. Lordship, I beg to mention for item number 16. Lordship, kindly adjourn the matter for the day.
Number?
16, 16.
At the request of the learned counsel for the petition appellant, the matter stands adjourned to be listed after vacation.
Obliged.
Item now.
I beg to mention item number 17 of daily list.
Absolutely no. Is
I
this the place where you change your wardrobe?
have not
Is
changed,
this the
Lordship.
way you are appearing out here wearing the gown out here before the court?
I was Lordship, wearing Lordship.
Then
Suddenly,
absolutely no. Nothing doing.
Lordship, I have filed an affidavit, Lordship.
Whatever you have filed, I'm not going to hear you. When a matter reaches, you can make the mention. The partner matter. That
cost has been deposited.
Huh?
Cost has been deposited.
deposited?
Deposited. After 8 months. Order.
The learned counsel appearing on behalf of the respondent, Mr. S.P. Roy, submits that the amount of rupees 50,000 has been deposited for the learned trial court on 25/6/2024, taking into account the above, and in that regard have placed before this court a certified copy of the order 5/4/2024, which is kept on record and marked with the letter X. S.R. Gogoi, the learned counsel, therefore appearing on behalf of the petitioner, therefore submits that he would not like to press the instant contempt proceedings. Accordingly, the contempt proceeding stands closed. Mr. Roy, this is the first time I'm doing it, but next time onwards, this type of matter is very serious.
Lordship, actual
But
fact is
there is an order being passed by this court. You were supposed to deposit, and then also you have the audacity on the last occasion to ask. This is a very serious thing.
No, Lordship, whatever it is a society, respondent number 1. They had, while the society is having a bank account, money is deposited there. They had filed an application before the bank to keep in suspension the operation of the account. So, Lordship,
I am not concerned with anything. There was a direction passed by the court for deposit of the 50,000. You should have done.
pay from his pocket, Lordship. Under the Societies Act, Lordship, members are not responsible. Only
There was a direction on a personal front to the petitioner number two and 3. On a personal front.
They are the office bearers. secretary.
Whatever may be, we are not concerned. There was on a personal note it was given. And as such, it was their duty to
but
deposit
they-
it,
they-
whatever may be.
Lordship, money was in bank. They will withdraw then only payment. That
We are
I'm
not
sorry,
concerned
even
because
for that
court
time.
was very clear that their imposition of 50,000 was not upon petitioner number 1. It was upon the petitioner number 2 and 3.
not so specified, Lord. Obliged.
For one,
Those persons are dispensed with.
1 and 2.
Yes, what is this?
This is a testamentary appeal method.
Hmm.
But in this probate case method, the land is given to us method, and the house constructed over the land is given to the respondent method.
Why the matter has been listed today?
The
It has been heard by another bench on 25/7/5. Heard both sides list for hearing on 27/6.
but it is connected with the RSA, one RSA, which has been disclosed by your lordship.
Huh?
One connected RSA is there, or their method.
Oh, that one.
Yes, method. Your
Now,
honor,
what case do you have here? You don't have a
that is
case.
over method. That is over method. Judgment has been delivered method. But it is.
You had a sister
Yes, method.
who was occupying the land.
Yes, method. That is.
And then what right do
This
you
is
have
not the
now?
property.
Huh?
This is not that property. It is separate property. Ancestral property, but it is separate property. It is mother given to her.
Then what happened?
Then my lord, the probate court, my lord,
No. Okay. Yes.
probate court granted the probate in respect of the land, my lord. After we have duly proved the will, my lord. But court on the allegation that the house constructed by the respondent's husband, although title is in the name of my father giving the property will to the daughter, two daughters. So by misconstruing the fact, Garnet district judge tried to decide the title of the house, my lord, because he has constructed. So partly allowed the land in our favor in the province. That is the case. They have challenged that provision.
This is the other plot of land
Other plot of land.
where the parents were staying.
Yes,
There was a will.
yes.
In whose favor?
Is my lord, two daughter, one Dipti Bhattakur and another is Aditi Sharma.
And
He died, my lord. Aditi Sharma died. She was unmarried. So only remained the Dipti Bhattakur, the present appellant. So my lord, already it is proved that is why the property is granted in respect of land, my lord. But regarding house, my lord,
now what happens when a person dies?
it is my
It
lord,
be only limited to one beneficiary or you did that?
two
or
beneficiaries.
If a two, one time,
One died.
what happens?
Actually, my
That's
lord,
that's share of her.
There will already inherited, my lord, because she has no heirs and such. She
So
unmarried.
therefore it will be going as per the class 2.
No,
Yes.
yes,
Then the brother's wife
yes,
would also be.
they will go undertake, my lord. Yeah, half portion they will undertake. They have no objection that we cannot object, my lord. But regarding the present daughter, my lord, Dipti Bhattakur, present appellant, the land, 50% of the land she will get by way of will, my lord.
So the probate application was dismissed.
Not dismissed, my lord. It is allowed regarding land, my lord, but house was granted to them, my lord.
Who is in possession of the house?
Actually, my lord, we are in possession because
They are in possession.
Huh?
My,
You are in possession of
Yes.
the house.
my-lord, in the.
So you
second-
have to file a suit for yeah. If I understand correctly, a probate proceedings, a person's right, that if he had any right, that is being transferred.
Yes,
But it is not that the, on the basis of a probate, no right, title and interest stands transferred. It is only his wish,
his wish, my-lord.
provided he has a right.
Yes, my, he has right, my-lord. That is not disputed. It is not disputed that my father has right. He also claimed the land to her husband.
But whether it is disputed the house,
She claimed that the house was constructed by her husband. So mere construction of a house of his father during the lifetime of his father, and by making some improvement, he cannot get the title, my-lord. He cannot get title, my-lord.
whether he gets a title or not, that is the subject matter of a suit.
Subject matter, my-lord, this is because whether in a probate case, my-lord, whether it is properly executed or not, we will have to prove. We prove, and title was not disputed. Father disputed. So probate should be granted, my-lord. That was not
It's
done.
okay, probate is
But
given.
he,
Now, what happens therefore, let us see what is the order passed.
order passed, my lord. Paper book in 41, my lord.
Huh?
Yeah,
You have paper book?
paper book, my lord.
Where is the paper book?
Two
Paper
columns.
book business. There are two, one,
Two F.
no paper book. Which judgment?
But it is testament appeal number 2/2007.
Aditi Sharma.
Yes, my lord. This is Dipti Portable. Aditi Sharma is the other sister who died, my lord.
How many probate applications were filed?
Two.
Why?
Two different plots, my lord. One plot is mother. Mother probated.
There are two wills.
Two each.
That the mother had the right over there.
Yes, it's mother.
Why? How? Is cast out. Plaintiff has failed to. The probate application was dismissed. In this case, test appeal case number 4,
Yes, my lord.
it was dismissed.
That is dismissed. Now, my lord, what happened that the,
This is by Aditi Sharma.
yes,
Now this has become infractious.
infectious. It is infectious because
Test
otherwise,
appeal number 4 of 2011. Taking into account that appellant had expired on
P117, my lord.
P1 2017. The instant appeal stands abated.
17.
So 4/2011 is gone.
Not 4, my lord. Yes. Yes, my lord.
So that is no longer necessary.
Yes, sir.
So that means she filed the AR for probate of which one? Their father.
Father, my lord, father also gave both brother, ODT and.
No. This probate was for what?
That
Was
is
it for letter of administration?
no, man.
For grant of probate of the will executed by her mother. This is the mother's one.
The mother's one.
So this is the mother's thing has gone.
Yes, ma'am.
So mother's will, what it will now be
is-
devolved in the state.
Yes.
So this goes. Comes to MC Aruna Chakraborty. What is this?
Owners of the, that is
This is in
cross
cross objection.
Yes, ma'am.
Keyboard Thakur. Who is Aruna Chakraborty?
Daughter of
Wife
brother.
Wife of the son of Ramakanta.
Why did he file this miss case? For granting leave to file cross objection. So this has been granted.
Not granted, my lord. Very
Then-
much. That was,
Is it required to be granted?
yes, my lord, that is by the order dated 21/6/12. It is written that prayer for the leave to file cross objection and
Is the
objection
crossover
for cross
cannot be
objection.
considered in view of the fact the same was filed after 4 years of receipt. Oh, this is not on the, yeah, this is on the basis of order 41 rule 22. Therefore, leave to file in man will be considered at the time when the appeal is heard. Now let us see the test case. This is against order.
After page 6.
We are now taking test case number 2 of 2007.
Yes, madam.
A.K. Sharma, the suit is for grant of probate which has been filed by one Dipti Bhattakur and her sister, one Aditya being the daughter of the filed one also. So your case is that while deciding issue number 2, it was categorically held that it was made by, built by your by your father, father.
Yes, ma'am.
And then it could not have been only given the land and not the house.
That is the point.
That's your case. And that is why they filed a cross objection
After 4 years, ma'am. That is,
after the date of receipt.
yes, ma'am. We have filed also objection also. In that case. On our CO method, we have filed objection method. My lord, in this case
But-
also,
Huh?
they can object here also. ma'am.
They can object here also. And apart from that, one thing, important thing is out here is about if it is held, if there is a dispute as regards the house, the probate does not decide anything about the house. So how do you say that the point number 2 was rightly decided by the learned district judge? He could not have decided that if that is your basic idea. Your submission also infringes upon this aspect of the matter.
Okay, but in the operative part of the last paragraph, my lord,
Here, if I am not wrong, the will, the probate court only will see as to whether the will was executed rightly or wrongly.
yes, ma'am. That
That's
is,
all.
that's all.
Now, thereupon, if any right accrues upon the will
Yes.
to you,
And if,
then in that case, you have to file a suit. If
Yes.
your right is being infringed. But how can the decision be given in respect to point number 2?
my lord,
Because don't you think that the learned district judge went far beyond what was required?
yes, my lord. He has given the, my lord, the house. He has given the house, my lord.
Understood.
Yes, my lord.
So, was it the jurisdiction of the probate court to go into the question of title, question of that who built the house, who did
Yes,
not build the
cannot,
house? Huh?
We cannot indeed provide.
Therefore, the point number 2 has been wrongly decided, could not have been decided at all.
Yes, ma'am.
Taking into account that the will has been done properly,
Yes,
which
ma'am.
is
Yeah.
point number 4. 4. Point number 3 and 4, that the will has been, there is no suspicious circumstances and the will has been done properly.
Yes, ma'am.
The probate could have been granted. And based upon the probate, you can have a very well a right for the purpose of that this property you have inherited from your father. And thereby you can very well take it up later on by evicting or asking if they create a cloud on you or your title. This is a subject matter of a suit.
Take matter of suit, because if it is not, it was not granted, my lord, then it will not come in the way of my right title interest. But moment she decided the possession regarding the house, then it is clouded, my lord. It is wrong judgment, my lord. He cannot decide.
Judgment is wrong.
Yes,
That
my
is what, no. Therefore, I'm saying point number 2 was wrongly decided. Could not have been decided. It is outside the scope of a
Yes,
probate
yes,
court. One can only challenge that there was no will.
yes,
That's all.
or fraudulent, or
Fraudulent.
yes,
And then they take into the stand of being a plaintiff. And it is their burden to show that has been fraudulently done.
Yes.
But the trial court went to the extent of saying that this property he has not made, or giving it the land and not the house. That I think needs an interference.
Yes.
In our cross objection, our stand has been that there is reasonable suspicion. There is reasonable suspicion, although there's,
No, it's okay. I understand your cross objection is as regards point number 2.
yes,
Point number 2, because you say your husband constructed it, the revenue receipts as well as all the municipal receipt, municipal permission were all in the name of your husband. Your specific case is that, look here, at that point of time, my father-in-law was there. He had only a brick house, a bamboo, with bamboo posts, some house out there. Now, temporary house, kacha house. Now it has been made permanent by my husband. And as such, he could not have granted the probate in respect to the house. But can that aspect of the matter be decided by the probate court?
Also, another aspect which has been completely ignored by the learned court below is why was he left out of the will?
He must have liked your the son,
That aspect was not addressed.
because may have been another thing that the side, he must have thought that this daughter of mine, the one daughter of mine, Aditi Sharma, she was unmarried, so she will stay with me and my wife. Therefore, I am not giving anything. But anyways, the other daughter may not like it, so I am giving it. Whereas the other, you have already purchased a plot of land from your uncle, and now you have a well-built house. Maybe. That's not for the court to have that
Another
wisdom
evidence
out
is there,
there.
my lord. There is strained relation between the father and son due to the marriage of this present defendant.
Exactly,
Because
because that is
they are
the
cast.
crux.
So, my lord, that is resolved, my lord, on the army.
Exactly.
No. That does not create a suspicion.
Actual.
That might have been an intentional. But that's not a suspicion.
Well, the fact that the will was executed at the house of the testator, that signals that the testator was not in sound mind. He was not in a position to go to the sub-registry, which is only less than a kilometer away from his home.
May not like to go to and stand in the queue. How does it matter? That is being proved by two at a.
They say they went
And
and
then why do you need
signed,
a?
my lord. They did not see
forget
him
about-
sign the.
Madam, why do you need at all particular that registration? Forget about the registration. We are not concerned with the registration. A will is without a registration. Also, a will is impossible.
Very well, my lord, but they did not see him affix his signature. Nowhere is there a statement that they saw him. All the witnesses that have been examined, no one says that I saw him affix his signature in their cross.
No. Why will they say in the cross if you don't put that question? In the chief, they must have 100%.
Even if the chief, my lord,
Is it, Mr.
not
Dekka?
there, my lord.
I don't think that
Not
is.
in the chief, nor in the
Because
cross.
it is the mandate of law that when you file a probate application, along with that, you have to also give the affidavit of that attesting witness.
My lord,
That's the law.
interestingly, the original will is not before this honorable court in the records.
No, we
I
don't
don't
require
find it, my lord.
We don't require it. But anyways, here is the case that under what circumstances this and you have not filed an appeal,
We filed a cross objection.
cross objection. We won't grant you the leave. Matter ends there. But you have not filed an appeal. Why? You are suspicious. You are the major purse because there is already a probate being granted in respect to the land. It has been held. It is you who should have filed an appeal.
The land, my lord, it has been decided
Cross
by this
objection.
honorable court in the second appeal. my
Madam,
lord.
kindly understand that there's a difference between a cross objection and an appeal.
Yes.
A cross objection is a thing by which some issues which otherwise touches on everything. If it is decided against you, but at the end of the day, you have got the relief out there before the trial court. Then you file a cross objection. But here is a case where the main relief has been granted to them that they are entitled to the probate.
They filed a suit, my lord, that was decided in the second appeal by this honorable court.
That is another land, nearby land.
It is the
That
same
land
one
belong-
kata 19 and a half.
No, that
acres.
is the nearby land. I remember. That belongs to the land which was sold in auction and then it was being purchased. So I remember that. Don't worry. This is a different land. Actually there were 4 brothers,
Yes, my lord.
of which this is one brother.
One brother, my lord, who had
And
bought it.
another brother's land which went into auction and that has been purchased
Bought
by your
by-
husband,
By the husband.
by your husband. and your sister, husband's sister was residing there, and therefore you filed a case for eviction, and he was claiming adverse possession. So that is another aspect. This is another land that belongs to the father. Why haven't you filed an appeal? You can't take it out by filing a cross objection means what? We file it later on also, it can be done, but you have to file it within 60 days from the date of receipt of the notice. Why after 4 years? What is the explanation? Better sense prevail later on. So, Mr. Becker, what should be the order passed to be passed by this court here?
It should be granted in toto, my lord. Probate should be granted, my lord, if they are in possession, my lord. Then you have to file suit, my lord, for eviction.
No, we have to interfere with point number 2. Because if I don't do it, this will act as a res judicator later on when you file a suit. And because of that, it will be binding on her. After all, a district judge's order. The point number 2 has to be interfered with. So the probate, in view of point number 3 and 4 being decided that there was no suspicious circumstances, the probate should have been granted as it is. Now, what happens in respect to the other beneficiary? Other beneficiary having died during the pendency of the instant appeal. What happens to that? Would she not be entitled to a part of it, the probate? Being a class 2 heir now.
Then go to the, this, her property will go to the legal heirs and unaffected by the probate.
No, whether if there are 2 beneficiaries, one beneficiary dies, what happens? Is it only limited to one beneficiary then? Or the other beneficiary, then the beneficiary who had died, yes, maybe before the probate it was done, it is different thing. But after getting a probate, the probate she has got.
Yes, ma'am.
You see, here you are only questioning that it should have been also the house, land and the house. That is why you are before this cause. Now, whatever may be the probate, Aditi Sharma had got it.
Yes.
And under such circumstances, if she is not there, then what happens?
Then, my lord, she will get the half, my lord. Present appeal, my lord.
No, she will not get half. She will get 3/4 if I'm not wrong.
Sure.
Because she is already has half.
Already half by way of will, my lord.
So another half from here.
Another half, my lord. She as a sister.
So it becomes 3/4.
My lord, not 3/4, my lord.
Why?
Because the daughter of prejudice son, my lord. Brother, prejudice brother. Present appellant is their wife, and 2 is the daughter of her brother.
No, I'm not concerned. They will also only get 1/4 of the share in respect to the probate. You see, there were 3 total of the Sobhapandian family. After the testator, his wife was there. Wife's case is gone. But the case of the other than the wife, there were 3 siblings.
Yes, ma'am.
Hmm.
And yes, ma'am.
Son's wife is before this court as a respondent.
Yes. Wife and daughter, ma'am.
And there are 2 daughters. One is Aditi and one is Dipti.
Yes.
Aditi expired. Beneficiaries were 2 as per the will. Aditi and Dipti. Aditi expired after getting a probate. Now, whether 50% of Aditi's share would go to her.
50%.
If it goes to her, this 50%, then wouldn't it be 3/4? Is what I'm saying.
3/4.
Anyways, you find it out. We'll have it after vacation, this aspect. Because I need to further know about this thing, how it has to be, what happens when a person dies. Because there is, if she had died prior to filing of the probate, is a different thing. But after getting a probate, what happens when all other parties are already there?
But one thing is there, my lord. The will itself, my lord. And I hereby appoint them, both of them. The said Srimati Aditi Sharma and Srimati Dipti Thakur, the sole executor of my this will. So both are them are executed. And,
Executors are different.
and my lord,
Who are the beneficiaries? Where's the will?
will is not in the paper book, my lord.
Not there.
It's not here before this court.
Such will it is called for, I think.
Not there, my lord. They could not find it. It's not there.
Why is this that there's no will in the court?
Right?
You have a copy of the will? Exhibit A is the will. Oh, it file to some, I'll see.
I am on to point out to that, in process of the entitled to at the time of my death. The said house and
Okay.
the vacant land on the front and rear side of the house shall be divided between my said two daughters in equal proportion according to their convenience.
No, it will be.
মাকাও কেসটা আছে কিন্তু ওকে এই কেসটা তো নাই
The attesting witness categorically stated that this person signed in front of us.
in the father's will, my lord, or the mother's?
Fathers. Fathers. Mothers is finished.
Yet to know why testing witness. But in their cross, my lord, they say both Harendranath and Tapan Bhattakur, they both say that they went and signed on the will
You
in the
didn't
cross
ask-
exam. They had signed.
They made it very categorically clear at the time of filing of the application also, as I told you. You need the attestation of it has to be also supported by the attesting witnesses. So the attesting witnesses also in the petition under 276 has done it. And they have also filed in the evidence. But here he says in his will that with existing privileges, chattels and tenants, there are title two at the time. Said house and the vacant land on the front and the rear side of shall be divided between my two said daughters in equal proportions.
Yes.
So under such circumstances, what will be the consequence in view of that?
But the beneficiary, that is present appellant, she has right to sue her share.
Hmm?
Right to sue her share, as per will itself.
Yes, she will get. There's no quarrel with that. She will get. But what about her?
After choosing his part, say her part, the remaining part, that will be divided as per heirs and successor will be the successive property.
No, taking into account that the probate has been, the appeal, the instant appeal is a continuation of the probate proceedings.
Yes.
If that be so, can you be said that when the matter is pending before this court, would it be amounting to granting probate against in favor of a dead person? Because if I interfere in certain extent as regards the land, then what happens?
Because if it is granted, then also dead person will.
No, that means you are granting a probate against a dead person. Can I give it? And by granting a probate against a dead person means there are two.
But my lord, not
If I directly dismiss the appeal, it's a different aspect of the matter where she may have a right. But if the moment I interfere, wouldn't that amount to have anything to do as regards the probate of a dead person?
my lord, not granting.
Hmm?
Not granting during the lifetime.
Because then the entire scenario changes. She also gets a right. 1/4. If she gets 1/4, it becomes another huge trouble for you.
Yes.
Think about it.
But my lord, after vacation will.
Because that is the important aspect.
Yes, my lord.
Her cross objection, I'm dismissing it. That's another thing. There's nothing out there. But the only thing I'm worrying on that if she gets, because it is her right will only flow once it is granted. And once it is only granted, when an appeal has been filed, it being a continuation, it won't be a granting because this order there will be a doctrine of merger. Once this merger happens, that order of granting probate loses its significance. Now, can I therefore grant against a dead person?
Moment.
Now, would it be only limited to him? Because it will have a lot of consequences. Think about it. Because if you see the wording of the will is, I will give it to my two daughters. What happens when one daughter dies?
But it is to the other daughter or not, my lord, that is
Huh?
also one aspect.
Will have some.
I come across one daughter in 1967, my lord. I will verify that. my lord.
Huh?
Judgment, my lord.
Huh.
I have forgotten that if two beneficiaries are there, my lord, one died, the entire property is given to the both of them, then the portion of the property of the disease will go to the other beneficiary. Like,
That seems to be a plausible explanation
yes.
because of the thing. Here is a case of a grant of a probate. This is not a devolution of a right.
Yes.
There's a difference between the
Probate,
two.
both daughter, my lord, excluding the other heirs and successor, my lord. That is why, my lord.
Hello, we'll have it after
Yes.
vacation. The matter having been heard at
Important
length.
point, my lord.
So 4 is gone.
Yes.
Four has been withdrawn, it is 4 to 2 years, it will be abated as so and so. 4 to হয়ে গেল না? Item number, there were two appeals, না? Let's go. এই তলৰটো number 2 এইটো order টো দিলো না? As a bit, LCR be returned, এইটো LCR টো গুচি যাব। A1 টোত লিখিব matter having been heard at length, this court and this court taking into account that one of the
Beneficiary.
two appellants had expired, leaving behind having expired, had sought a query from Mr. P.S. Dekar, the learned senior counsel, as to what would be the effect of the grant of the probate by the impugned judgment dated 16/12/2006 in favor of both the appellants. Taking into account above, the learned counsel, senior counsel submits that some time may be granted. Accordingly, list the matter again on, we finish it on 23rd of July, 2024, at the top of the list showing it as authored. So we dismiss the cross objection. What is there, the cross objection to do? Necessary files.
Point raised by your lordship was not made in cross objection. This is the important point.
That is the most important
yes.
point. Anyways, let our hopes remain that I may change my mood on that day. Very good. Wait, an option? What's he?
Tell me,
This.
but your lordship, the appellant number 1 has died in the meantime. On 26/12.
How? Who died?
The appellant number 1, Umaruddin Ahmad. Plaintiff appellant number 1,
Who died? Appellant number 1,
Umaruddin Ahmad.
Umaruddin. Who is this? Nasiruddin?
Nasiruddin is the brother, younger brother, and defendant is the respondent is the middle brother.
Kamaruddin alive?
Kamaruddin has
Never
also
died.
died.
And who is alive?
Nasiruddin is alive.
Nasiruddin is alive. So only two is alive. And Kamaruddin has been substituted.
Yes.
On the death by Sevas Begum so and so. Okay. Now let us see what is the appeal.
Appeal is we
Which
filed a
order? Is that order?
order dated 8/11/2008.
Huh?
8/11/2008 passed by the appellate court below.
Seven.
At page 57, Your Honor.
Page 11?
Page 57.
Uh,
57. Order dated 8 August 2008.
Who is the plaintiff?
I am the plaintiff. I am one of the plaintiff.
What is your suit for?
For right title and right title interest of the Pakka land and also the house standing thereof. Now in the house, there were 6 rooms, out of which 2 rooms and 1 kitchen was occupied illegally by the defendant. Respondent.
And the suit filed when?
Suit filed in the year 1984.
84.
Yes.
And why is it the appellate courts have been always framing 3 issues?
Remanding the matter back.
And after deciding these 3 issues, framing, did the trial court decide all the issues only or the 3 issues?
3 additional issues which was
Only those.
those were decided. Thereafter, again, the defendant filed another appeal.
No, no, understood. So only these 3 issues were decided, not the others.
Others, the issues which were priorly framed, that was decided by the trial court.
Now, by that new judgment,
By the new judgment, 3.
only 3. But the earlier judgment was, it was remanded to decide afresh.
Yes.
So obviously it is a case of remand.
But the later issue which was framed, that
There are another additional, whether the tenancy in respect of the suit properties were surrendered to Gul Muhammad Sardar by late Dukhon Mia, the father of the parties, before execution of the sale deed. Yes.
that is irrelevant issue because by dint of the sale deed, that is 4/5/1967, we have already established our right title in the entire suit line and also the house standing there.
By 411 is what?
4/5/1967. That is a sale deed.
Show me the trial court's second judgment.
Right. Oops. Starts from page 17, your lordship. That is the first. Page 46, your lordship.
Now, one thing, show me prior to that, the first appellate court judgment.
Page 50.
So here, this is the case where only 3 issues were framed and the judgment was set aside.
Was set aside.
If the judgment was set aside, then isn't it the necessity in view of Order 14 Rule 2 to again decide all the issues afresh?
Yes.
If that be so, what is this? The appellate court is not wrong in that. So why should we interfere? At the end of the day, you want to throw them out. And by this process, you have been very successful in keeping this matter pending for last 15 years. 15 years, another 14, 16 there, another 9 there. 16, 15, 31 plus 9, 40 years. Fantastic. We dismiss it. Order is right. Because the first appellate order categorically says that 3 issues are framed and the judgment and decree passed by the learned trial court is set aside. Therefore, it is a mandatory duty to decide all the issues. You have confined, the trial court only confined to these 3 additional issues. Another issue, they have framed it. Anyways, it is going back. Let it be done. They want another 4, 5 issues, let them also put it there. Be happy. At the end of the day, your aim should be to how to throw him out. Or you want that your grandchildren also file this. Then it
Your
seems
lordship,
something like that.
Let this matter come up after vacation. My senior. will be-
Absolutely no. This is a matter to be said, there's no quarrel with the fact that this matter has to be, the appeal has to be dismissed because the trial court was wrong. At the end of the day, if it comes up after the vacations, it is another 1 month delay.
1 month.
Who is your senior?
Yes, sir. CC Datta,
Where is he?
another.
Ask him to come. I'll dictate it in his presence. Or does he wants that your, not his, your grandchildren wants to fight this litigation?
Obliged.
Madam, we'll dismiss this appeal. There's no quarrel. So you want to do, I want to do it on the face of Mr. C.C. Doctor, senior advocate, not in front of the junior S. Doctor.
Item 5.
Yes, Mr. Sharma.
What about my lord? The case of my lord, this standard tenant, my lord. The tenant
Which
is-
order you are challenging?
My lord, the order challenge is one of the, at page 23, in Excel B.
23.
What about my lord here, actually, judgment of this court, my lord, dated in 2016. Here, instead of remanding the matter to decide this, my lord, what happened, we are also unmindful. The entire judgment of the lower court was set aside.
Where's the order passed by this court?
My lord, page 11. Here, my lord, who you are also unmindful, my lord, that lower court entire judgment was set aside. And instead of remanding the matter to decide the particular issue of terms of the counterfoil and the inner and outer foil. Parents. There go 16, my lord. Page 21.
So, Sharma, what do you say about the judgment passed by my coordinate bench? After having set aside the judgment, isn't it open then?
You can file.
How can you kindly come to page 21, paragraph number
Yes,
16?
that's why I'm-
How do you conceive that it must be a suit for recovery of possession, means landlord tenant?
yes.
Now, kindly see how is hereby set aside and called. The matter is remanded back to the trial court for deciding the limited question as to whether the outer counterfoil of the rent received by the year bears the signature of the plaintiff in correction. Then
Yes. No, no, what
isn't the suit now open? But the limited evidence to be given is only that.
No, it is open matter because the earlier suit, judgment and declaration set aside.
But the only limited scope of the evidence which is there
Yes.
is for comparing of exhibit E.
Exhibit.
Then why you asking for F?
If it's enough way, my side. Who's I retained, as alien lady?
Whatever may be, you are asking for F, and the court has been clear because there was the only limited scope on which it was interfered with. The limited scope was that it was only exhibit E was not compared.
And my lord, he was, my lord, not compared any. Your lordship, I say, I also obtained the separate copy of the E. Exhibit E.
No, unless I can't touch it because in view of paragraph 16.
Yes.
So in view of that, it is only exhibit
All
E.
right, my lord. If
So
the-
unless you file a review against this order, how can I touch it?
the-
Trial court
well,
cannot be said to
Now
be
9
wrong.
years, my lord.
No, maybe, but this is what it is the scope of exhibit E.
No, exhibit E was, my lord, all right.
Now,
But what even, my lord, the exhibit E was only outwardly verified by the court. It was not said to be any forensic lab or anything. That's what our grievance was in the petition also. To the
no,
court.
only ground on which it was set aside is not comparing the signatures in exhibit E.
Yes.
And therefore, the
Now,
limited
question is, my
question
lord-
on which it was remanded
Yes.
back was E.
No, now question is whether we can go for press shoot. Whether it will barred by res judicata.
Why?
Of course, the
Landlord tenant,
landlord.
every time there is a new cause of action. You can very well go for every time a new cause of action, not the cause of action which was there earlier
Yes.
and decided. That is another thing. You can very well go for another cause of action. Res judicata is not there. As of now, there is no decision. Where is the decision? Is there any decision? No. So you can very well go.
That's what we are worried about. Otherwise, we will not.
Then what to do? Dismiss.
Both of my submission, that's all.
Huh?
It's my submission, we are, we are afraid of them, we are scared of the fact that whether it will barred by res judicata.
That is not the question before this court. You are asking me, I am answering it. That's a different thing. That is not the question. Here is whether exhibit F should have been sent to handwriting expert. When the limited question on which it was to be sent was only exhibit E. And the trial court seems to be right.
Was, my lord, there was clear manipulation. That was not examined by.
But that is not the scope in which it is being given. What? Dismiss?
Not this way,
Withdraw?
it's,
The R.P. Sharma, the learned counsel, senior counsel appearing on behalf of the petitioner submits that he not like to press the instant petition which have been filed challenging the order dated.
Because I don't have instruction to that.
Huh?
I don't have instruction not to press it.
No, then I have to say it. In that regard, I have to dismiss it. Dismiss.
Yeah, give me observation. And recording my submission, my lord. Submission will just print it.
An application under Article 227 of the Constitution challenging the order date 10/2023 passed in petition number 305/2013 arising out of title suit number 110/1999. By the impugned order dated 3/10/2023, the learned trial court, that is the court of the Civil Judge Junior Division number 5, Kachar, Silchar, had rejected the application for sending exhibit 1 Roman 1 and exhibit F that is the rent receipts, both inner and outer foil, marked as exhibit 1-1, exhibit 1 Roman 2, exhibit 1 Roman 3, exhibit F, exhibit F1, exhibit F2 to the handwriting expert for ascertaining the authors of the signature of the said rent receipts. By the impugned order, it is so and so. Exhibit 1-1, comma, exhibit 1-2, exhibit 1-3, and exhibit exhibit F1, exhibit F2 to the handwriting expert of the Directorate of Forensic Science, Kailipara. The reason assigned in the said order is that this court, in its order dated, in its judgment dated 27/5/2016, passed in civil revision petition number 360/2011, had only directed sending exhibit E, E for examination of the handwriting expert and not exhibit F. So this court have also duly taken note of the judgment and order passed by this court on 27/5/2016 in civil revision petition number 360/2011, and paragraphs and the directions so passed in the said judgment, more particularly at paragraph number 15, is reproduced here in under page 21 of POW. From a perusal of the above order, it is seen that that this court had made it categorically clear that only the signatures of the plaintiff only the admitted signatures of the plaintiff are to be compared with exhibit E, that is the outer counterfoil of the rent receipt. And in that regard, had remanded the suit back to the trial court for deciding that limited question as to whether the outer counterfoil of the rent receipt is exhibited by defendant bears the signature of the plaintiff. Under such circumstances, as the suit was remanded only on the said aspect of the matter, the further evidence which is required to be taken is also limited to that extent. Consequently, this court, therefore, finds no infirmity in the order dated 3/10/2023 passed impugned in the instant proceedings, for which the instant proceeding stands dismissed. Yes, Mr. Doctor. I am being told that you want your great grandson to also have
Timing item 3.
doing that matter.
But,
What is wrong with that order?
no, the proposition of your lordships, my learned friend has intimated me. I feel it's quite okay.
It's 40 years have gone.
Yes,
At the end of the day, you want him to vacate. And it is not having this way or that way.
very right. Very right.
So remand, this court does not like it, and more particularly in view of the Constitution recent judgment, makes it very clear the remand should be the last resort. But here there is no other resort. There were judgment and decree having been set aside.
Let us set by the update.
The trial court could not have only decided these 3 additional issues alone.
What we have decided all the issues together. Lordship may dispose of that.
The instant second appeal, this is an appeal under Order 43, Rule 1(2) of the Code of Civil Procedure 1908, challenging the order dated 8/8/2008, passed in title appeal number 4/1998, whereby 1998.
Yes.
Are you sure?
2008.
8/8/2008 is okay. The appeal of 1998,
Yes, yes.
Filed on 4/98.
No, these.
4/1998 to the
Decided on
The title appeal is
No.
498, decided on
4/1998,
2008.
whereby the learned First Appellate Court, that is the Court of the Civil Judge Dibrugarh, had remanded the suit back to the learned trial court for deciding afresh and also had framed an additional issue. First, I've heard Mr. S. Dutta, the learned senior counsel, assisted by Mr. S. Dutta, the learned counsel, appearing on behalf of the appellant, and Ms. B. Dutta, the learned senior counsel, assisted by, and so. Give the name, huh? Yes. From a perusal of the materials on record, it reveals that the appellants herein as plaintiffs had filed a suit for seeking declaration of their right, title, and interest to the 3 rooms of the house from the northern side with kitchen behind, standing on the land under municipal holding number 4290 of Dibrugarh municipality, semicolon, for khas possession of the northern 3 rooms of the house with kitchen behind in illegal possession of the defendant as described in Schedule B to the plaint for cost, etc. The defendant filed his written statement denying the case of the plaintiff. On the basis of the pleadings, the learned trial court framed as many as 9 issues. Subsequent thereto, after judgment was delivered, subsequent thereto, a judgment and decree was passed on (31 1989), whereby the suit of the plaintiff was decreed on contest with cost, and the defendant was allowed 1 month time to vacate the 3 rooms described in the Schedule B to the plaint. Being aggrieved, suit to number to deliver the title of 1984. Being aggrieved, an appeal was preferred by the defendant, which was registered and numbered as title appeal number 6/1993. The said appeal was disposed of by an order dated what is this order date? As an order dated 23rd of February 23 to 1995. Whereby the judgment and decree passed by the learned trial court dated 31 1989 in title suit number 93/1984 was set aside, and the suit was remanded back to the learned trial court by framing 3 additional issues. The learned trial court thereupon post remand, again passed another judgment and decree on 19/11/1997, whereby The plaintiff's suit was again decreed on contest with cost. And the defendant was allowed 2 months' time to vacate the premises described in the Schedule B of the plaint drawn up of the plaint. Full stop. However, most surprisingly, the learned trial court did not decide the earlier issues, the earlier 9 issues, the other 9 issues, and confined its adjudication into the 3 additional issues framed by the learned appellate court. Being aggrieved, an appeal was prepared, which was registered and numbered as title appeal number 4/1998. And the said appeal was disposed of by an order dated 8/8/2008, whereby the suit was again remanded back to the learned trial court in view of not deciding the other 9 issues and further framing an additional issue. Being aggrieved, the appeal thereupon was preferred. The instant appeal has been preferred against the order dated 8/8/2008, passed in title appeal number 4/1998. Hey, the Constitution bench of judgment was yet. Could go I'm writing a lengthier one only for the purpose that no, there should not be any further remand.
Yes.
This time it's okay, but can't help it. কি ক'ত গ'ল কি আধা বেলা নাই কি আধা বেলা আমিও ক'ৰ্টৰ পৰা এনেকে মাজত যাব পাৰি নেকি
But I don't know whether my learned friend intimated. The one of the appellant expired in the meantime.
I know that, but keeping it out here does not make any sense. You go and substitute there. As you have not done it here,
Given of them.
then that I'll do it. I'm trying to nowadays make it very simple. Unnecessarily making it very complicated, it becomes too technical.
Right.
And at the end of the day, people are suffering. Football. Is the fellow? Ask him. মই ইয়াত ৰাখিব লাগিব। এই নাপালো সিদিনা যে ওলাইছিলো মই যে কৈছিলো ক'ত গ'লে this court have duly taken note of that the suit has been filed in the year 1984. And as this court takes up the instant appeal, "40 years have now passed by. It is unfortunate that this is the second time that the suit has been remanded back to the trial court. In fact, in a recent judgment of the Constitution bench of the Supreme Court in the case of the High Court Bar Association Allahabad versus the state of UP and others, reported in 2024 SCC Online SC 207, the Supreme Court had deprecated this practice. By observing, the Constitution bench of the Supreme Court had deprecated this practice by observing that in our legal system, which is facing a docket explosion, an order of remand should be made only as a last resort. Inasmuch as orders of remand not only results in more delay, but also increase the cost of litigation. This court is mindful of the said observation. But what is seen from the proceedings, from the manner in which the proceedings of the suit is that pursuant to a suit being decreed, the appellate court, the first appellate court, interferes with the said judgment and decree passed by the learned trial court and remands the suit by framing 3 additional issues. The trial court seemed to be unaware of the provisions of Order 14, which stipulates that the court has to decide all the issues, had confined its adjudication only to the additional issues framed by the learned first appellate court. This has resulted in another appeal being filed in the year 1998. Wherein the impugned order has been passed. Taking into account that the learned trial court did not decide the other issues, which is otherwise the mandate of law, The learned first appellate court had no other option but to remand it back by the impugned order. This court expresses remorse to the plight of both the parties who have been fighting this litigation for the last 40 years. And after this period, again, coming back to the situation where they were in the year 1984. Under such circumstances, this court is not interfering with the impugned order dated 8/8/2008. Taking into account that the learned first appellate court had no other option but to remand the suit back to the trial court. However, taking into account that both the parties are duly represented, this court directs both the parties to appear before the learned court of the Munsif. It will be Munsif now. Munsif, Dibrugarh. Munsif. Dibrugarh. Nowadays it is civil judge or one or Munsif. Munsif, huh?
Civil judge junior division.
You have junior division or Munsif? Munsif, na?
Earlier it was junior
Civil
division.
judge, junior division.
Junior division. Okay. Civil judge, junior division number 1. That is the trial court. On 19th of August 2024. The learned trial court shall take appropriate steps for disposal of the said suit as per the directions passed by in the impugned order dated 8/8/2008 in title appeal number 4/1998 within a time frame. This court, however, takes note of, before parting with the record, this court takes note of. Records be sent so and so for tweet and a special messenger and all. Actually, before parting with the record, this court duly takes note of that the appellant number 1 had expired. But taking into account that the instant appeal, taking into account that both the appellants were co-owners of the land, the instant appeal has not abated. The petition is the appellants herein, who are the plaintiffs, are given the liberty to file appropriate application before the trial court, if so advised, to file substitution application insofar as the plaintiff number 1. The above the instant appeal stand. Can you again?
What's up?
This second appeal against orders has to be finished. Unless it can't be for this for so many years. I've finished up most of it. I'm just
Which can be done by your lordship.
no, I'm finishing up because otherwise all suits are getting stayed. And I think there's way less now. Every day I catch hold of one and
Yesterday I could not even go into the treatment. It was severe pain.
which order?
Order, my lord, 26/6/2003. At page 12.
Page
12.
12.
This much I can say, my lord. Don't say more.
Yes, what is there to challenge?
My lord, today I am not prepared.
It's come for motion. I'm vacating the interim order. This question of interim order does not arise at all.
Because of my lord,
Absolutely, the law is very well settled. This is depends upon the court, and the court has exercised the discretion and thereby
Sir.
permitting. We are not ready to not exercising the year for vacate till the next date. I'm not extending the stay. You want this? We can have it as
Sir,
a
there are some
practical question.
decisions-
What do you call it? A
there are some
question?
decision on this point, my lord.
Huh?
There are some decision on this point. It is said that, my lord, it is mandatory.
No,
Yes, my lord.
no. There
Supreme-
cannot be any judgment out there.
Salim Bar
There's a Supreme
Association-
Court judgment categorically
my lord,
says that
Salim-
this is
Salim
not.
Bar Association says the court may exercise discretion or should give one more chance. But there must have some judicial discretion based on judicial satisfaction. In my lord, 2019 Supreme Court says it can and must be redacted.
To me, where? Under 11F.
And I am not fully prepared today.
Show me that judgment where it says that it must be.
Yes,
Thus also be knowledgeable about this. Yes, what is the judgment name?
my lord. Madhav Prasad Agarwal.
Huh?
Madhav Prasad
What is the
Agarwal.
citation?
Citation is, my lord. I can say, my lord, give the title as well as the date of judgment.
Okay, name?
Madhav Prasad Agarwal
M-A,
versus Axis Bank Limited,
M-A-D,
MADHAV. Prasad Agarwal. Another versus Axis Bank Limited and another. Paragraph 13. Calcutta High Court also, my lord, arrived at the same conclusion.
this paragraph? Which paragraph
13.
you are referring to the judgment?
13. I'm just reading, my lord. Inevitably, undoubtedly, the plain can and must be redacted in exercise of powers under Order 7, Rule 11D, CPC, on account of
D. D is different. We are not concerned with D, we are concerned with F.
E is in respect of, my lord.
When
in
it is
respect
barred.
of- There is some procedural irregularity.
No,
Yes, and you see,
absolutely no. Which paragraph you are referring to?
There are 13. That's why, my lord, I want to argue the matter in a proper manner.
Indubitably, the plaint can and must be rejected in exercise of the powers under Order 7, Rule 11D on account of non-compliance with the mandatory requirements or being replicate with an institutional deficiency at the time of presentation ascribed under clause A to F of so and so. In other words, the plaint as presented must proceed as a whole or can be rejected as a whole, but no part of it. In that regard, the relief claimed by the so and so in the notice here, which commended the High Court, is clearly a jurisdictional. We do not wish to dilate the argument and so and so. 11D and 11A is a must. All judgments are there. 11A and 11D, not F.
F, my lord, F says, certain bar association case, my lord, says, once the matter has come to the court, and there is some materials before the court, and if court on consideration of the materials is of the judicial, my lord, opinion, based on judicial satisfaction.
Let us admit this thing and vacate the stay. After 10 years, we can hear this. In the meantime,
I am just
Mr.
praying-
Alam, try to finish off this.
My lord, I am just praying for a week time.
Absolutely no. There's nothing. This type of matter should not be there. Unnecessary matter.
Well, I want to argue the matter, my lord.
Argue. I'm giving you the opportunity to argue.
Yeah, my lord, okay, only
You
for-
cannot say that.
everybody
You
has-
cannot say that you cannot.
my
You
lord,
are not in a
everybody has got
position
some
to
personal
argue.
Problem, my lord, because of my injury, I could not prepare the case. I am trying to apprise the court. And he accorded me, I have taken the consent.
Okay, but I'm not extending. Then
Otherwise, my lord, absolutely meaningless.
absolutely, that is your lookout. That is it is till today. I have to extend it. You want an adjournment? I can have it any other day.
Now, this type of condition, my lord,
I can't help it.
because
Because the conscience of this court does not permit an
if
extension
your
of this
lordship
interim
impose
order.
that condition, then I.
When do you want it? Next year?
15th, my lord, on the opening day.
Chalo. The council appearing on behalf of the petitioner seeks for an accommodation to be listed after the vacation, list the matter immediately after vacations.
I obliged, my lord, only because of that. Normally, I used to appear and argue the matter. Particularly this
Mr.
court.
Purkayastha, your hand got fractured 5-6 days back and thereafter
No,
you
my
have
lord,
done this matter.
Yesterday, my lord, I went to doctor. Doctor said you go and further X-ray on Saturday.
Yesterday you argued the matter before me. In spite of earlier falling, I know I have granted an adjournment earlier on that ground.
Yes, that's
Then-
right. Even then, pain is
O-
continuing.
Only on the ground that now you have got the medication, now you have a better cause.
I'm always, my lord, grateful to your lordship. my lord. Much obliged. Yes.
Oh, indeed.
Hello, 7.
Yes. Yes, what is this?
Debarring the defendants from filing their written statement on account of my lord elapse of the statutory period of 90 days.
And by filing has been paid for keeping the yard till the dispo another employee which have filed pleading for preliminary issues regarding. Which order?
That lordship will find it page 64. Page 64, my lord, in the main source.
This one,
Yes, page 64,
only challenging 23/11/2022.
23/11/2022. Because by this order now, my lord, we have pleaded a specific case out here. That it was, my lord, on account of default committed by the earlier set of councils.
Hmm.
Now, my lord, on 23.
Mr. Borbujari, first and foremost, this court does not like to hear any complaints with your fellow councils. Kindly don't make it. If you have anything, put it to the bar council, the bar council will take it. Not
I'm
you.
representing my client, so it is the client's person,
So what?
the client's person.
Okay, if that is the ground, I'll dismiss it on that ground. Yes, tell me.
So here, my lord, on 23/11/2022,
Why haven't you challenged this order earlier?
earlier, my lord, because again there was a change in the set of councils.
So only on the council, and you have not filed any application earlier against the bar council.
Because on 23/11/2022, the written statement ought to have been filed. But they filed an application, my lord, that lordship will find that, my lord, page 58. Kindly see page 58.
Yeah, I can't take up this matter. This my client earlier. Anyways, I won't. This is the matter before any other court. Order 2311 first part is absolutely okay. There cannot be a preliminary issue framed without a written statement. It is nobody it is not heard of. But as regards the second part of it, without notice, I can't. But anyways, it is a case to be dismissed on the first day, but I can't take it up.
They ought to have filed a written statement, the blunder they have committed, my lord, we committed that we filed an application for keeping in abeyance the filing of written statement till this issue is decided.
How can there be an issue? Tell
Yes.
me. Is it heard of?
That is why, my lord, I had pointed out before the court.
No, understood. How
As a-
can an
as-
issue
as-
be there without a written statement?
Therefore, my lord, as counsels, as advocates, my lord, we should be conscious of the procedure. Now, the procedure,
First of all, isn't it your client's mistake to appoint him?
they were not informed. that is also
Informed or
our
not
pleaded
informed, how does it matter?
I am obliged.
So on instruction, I would like to withdraw this petition, my lord.
You want to withdraw?
Yes, my lord. Take liberty to approach the appropriate forum, my lord.
What? You are challenging which order?
But I have challenged, page 99, my lord. Section 14. I filed an, IA in DRT, my lord. That was rejected. Against that order, I have filed this, CRT, my lord. During the course of the hearing, my lord, my learned-
The learned counsel appearing on behalf of, this is a petition under Article 227 of the Constitution challenging the order dated 12/2/2024 passed in OA number 305/2020 by the Learned Debt Recovery Tribunal, Guwahati. The learned counsel appearing on behalf of the petitioner submits that he has instructions not to press the instant petition. He, however, submits that withdrawal of the instant petition should not preclude the petitioner to avail other remedies if available under law. Also, taking into account the above, the instant petition stands closed on withdrawal. So withdrawal.
My presence may be recorded. I'm a for respondent number one.
Withdrawal of the instant petition would not prejudice the petitioners if ill remedies if otherwise available under.
My presence may be recorded.
Down, give it.
I have already appeared on the last call.
Okay, well, give your name, they will put. Yes, what is this?
The petitioner, defendant, as a defendant, I just showed, filed an application for amendment of WS that was rejected. But subsequently wrongly filed a misappeal before the additional decision. And that was also dismissed. Actually, ought not filed, but wrongly filed the learned counsel. Hence, the petitioner put before reasonable court by two orders of impugn. And first order dated annexure 5 at page 35. In other page 36, start from 35.
Does it rejected?
Rejected is, the defendant ought to have filed stated in his WS that plea which is taken for defense. The earlier engaged counsel ought to have filed the same, but ought not. That's why file an application under order 617 for amendment of WS.
What is the stage of the suit?
It's cross-examination of PW.
Now you want to amend? Why should we allow it?
Actually, what happened? The defendant, basically, defendant was the owner of the suit images, and subsequently, fraudulently, the plaintiff executed a sale deed.
You challenge the sale deed.
That's why. he
But
was-
why do you need it here? You have to file a suit for that.
No, I'm not filed. You filed by
For
the
that, you have to file a suit.
suit.
How does this have any relevance?
No.
You are now challenging by way of a amendment to a written statement.
Actually, suit, the plaintiff filed a suit. I'm a tenant. Defendant is a tenant. Actually, he's the owner, was the owner.
Understood. For that, if there is a sale deed, don't you have to challenge it?
No.
Why?
The learned counsel had not takes that plea. That's why subsequently one advocate, Ujjwal Phukon, appeared on behalf of the defendant. He filed this present application for amendment.
Understood. But don't you think that you need to file a challenge the sale deed?
Yes,
If you have not challenged it, why are you making these type of amendments?
not challenge, not challenge.
So why you are not filing that suit instead of spoiling your time in fighting all these things?
Or to have filed a counterclaim.
Yes.
Or not filed.
Okay, yes, counterclaim you can do, but now it is a suit at the stage of cross.
Course.
So don't you think that you need to file a suit? Challenging this sale,
Yes.
because without challenge to the sale deed, you cannot. Merely stating out there has no relevance.
I instructed, but they have filed, they didn't whatever. There is no hope. Present case, it's a hopeless case. Because wrongly filed a appeal against the rejection of amendment.
Understood? You can't.
So Lordship may then maybe allow, otherwise up to you, Lordship.
What?
They consider,
No.
Take
First of all, why should we? Now, it's at the stage of cross-examination of the DW,
no, PW.
PW. Then, now
think
if the
PW
suit will go back to the again to the pleadings. Issues have to be framed. But are these issues relevant? That you are the owner?
Actually relevant because I am the owner.
Understood, but you have to file a suit or counterclaim.
It is
Unless you challenge the sale deed, there is a sale deed, which now therefore shows either you are a tenant or whatever it may be. But in your written statement, you have what did you say?
actually the plea taken for
Let's
amendment
see your
is
written
the
statement.
additional ground for defense.
Let us see what is the written statement.
He has said
Suit for recovery
Right.
of area rent. What is your written statement?
paragraph 5 in progress.
So you have already stated that. Why do you need this amendment now? Where is your amendment petition?
Actually, there is a part of the counterclaim also that they want to amend the WS and file counterclaim. But that part has already over.
No.
Issue has already framed. That part has already precluded.
Now, an application under order 6 rule 17,
Yes.
order 8, as well as one here. The defendant has filed a written statement. The real business for filing. Where's your petition under order 6 rule 70?
At Annex 3, page 26,
Page
26.
20,
Page 26,
26.
yes.
What are you asking for? What is to be inserted? Yes,
It's 26 in my,
understood, page 26. What do you want to insert, amend?
that is a petition for amendment,
Understood. What do you want to amend? The written statement.
yes.
So you have to say what you want to amend. Is anything written out here?
Definitely not. That's right.
Is this something to do with your holiday bonus or something?
Only paragraph, only paragraph 3,
Yes.
only paragraph 3,
Sir L.K. Bora, withdraw this. Do whatever you like. You have already those statement in paragraph number 5.
I want to withdraw.
Nothing out. The L.K. Bora, the learned counsel submits that the hearing would be well advised to file a suit challenging the deed of sale rather than of the written statement. He further submits petition under order 6 rule 17 of also does not contain what are the proposed amendments of. And as such, he not like to further press the instant. He however submits that the withdrawal of the instant petitions not preclude the petitioner to ill remedies or including filing of a suit for challenging the deed of sale. Into account above the this on withdrawal. However, it is made clear that the dismissal of the instant petition on withdrawal shall not preclude the bill other remedies if so. Highest I hope this order saying filing of a suit, what your submission put something in the mind of your client. Then
My business.
yeah, what is this?
Petitioner appointed an attorney for looking after his business and for sale of a piece of land. The attorney executed an agreement to sell with one of the witnesses. Thereafter, a case for specific purpose has been filed by that witness as a plaintiff, and me as a defendant through this attorney, represented by this attorney. Now, attorney received the notice, then allowed it to be exported. He exported order. They take this lordship to page 56. He did not file the written statement, not even Okalaknama. Attorney. Attorney received the notice, but after this impugned order, lordship first order is 1/11/2022 first to proceed expertise evidence. Thereafter, I came to know and I came down to Silchar lordship and I stay in Gurgaon. File an application to an advocate for setting aside.
What is the stage of the suit?
Now lordship on 13/6 it was for argument. On that date,
What?
argument. They have filed evidence. Thereafter, it was fixed for argument. We informed the court that we approached the Honorable High Court. It was filed on 12/6. And next date it was fixed for 3/7 for order from the High Court. We had to produce an order of the High Court.
You want a dismissal order right away.
Lordship, here I am a victim of the circumstance. If
Did you file any
Yes,
case
yes.
against your attorney?
case has not been filed. No
Why?
case has been filed.
Isn't it the service, if meted out to your person who is duly authorized, is deemed service, proper service?
Yes, but
If the power of attorney agent has been empowered to file written statement,
yes.
then in that case, if he does not do so, wouldn't the principle of holding out apply to you? And if it applies, you are equally responsible.
That is my problem.
So
There is a
It's
power
a
for
mercy,
filing written
it's a
statement.
mercy petition. It's a mercy petition. You don't have any right.
At least lordship, I understand it is 22, matter is also 22 matter suit.
22 method.
2022. Case.
So what?
Suit was filed.
You want another 10 years to go by this way?
No, Lordship.
Then
What happened, Lordship, the agreement has been executed showing the consideration price to be rupees 50 lakh, out of which 14 lakh has been shown to be paid to the attorney.
didn't you,
49 lakh.
didn't you empower your attorney to receive it?
Yes, Lordship. I think.
Means you have empowered. Then
No, that is my problem. This case, the victim of circumstance entirely. He
I-
filed an application, Lordship, for vacating the expiry order, but unfortunately it was filed under Order 9 Rule 13 with an application for condonation of delay. That application for condonation of delay has been rejected. Thereafter, he filed an application under Order 9 Rule 7. That was also rejected. That earlier same similar prayer was rejected.
who filed an petition under Order 9 Rule 13?
It is through me. This I have filed. That order is at page 83.
Okay. Issue notice making it returnable by 2nd of September 2024. Steps be taken by registered as well as usual on the respondent. Petitioner is further directed to take steps by way of trustee routed through the registry of this court and file an affidavit of cert. This court, the instant petition has been filed challenging the order dated 14/3/2024, passed by the learned court of the civil judge, senior division number 1, in Mize case number 288, rising out of title suit number 113 of, whereby the application under Order 9 Rule 7 of the code read with section 151 of the CPC, setting aside the ex parte order dated 1/11/2022, was rejected. This court have duly taken note of the impugned order, and prima facie, it is the opinion of this court that the matter would require, and prima facie, it is the opinion of this court that the impugned order and this court is of the opinion that the impugned order, prima facie, it's the opinion of this court that the impugned order may require interference. But under such circumstances, this court states further proceedings of title suit number 113 of the 2022 till the next stage. Mr. Purkastra, your ground is different. Your ground is to the effect that you filed Order 9 Rule 13 wrongly. There is no limitation. It was rejected. Order 9 Rule 13 does not apply at all when the suit is alive, unless there is a decree. So that order should not have been taken into consideration
Yes.
at all.
Yes.
And further to that, at the time when you have filed that, the court should have taken into account it was made mistakenly, and therefore Order 9 Rule
Very-
7 should have been relegated to that position.
On merit, it could have been filed first.
See, to that position, not from the date of filing of that. You see, Order 9 Rule 7 is on a different, you show good cause, you get relegated to that. If you don't show, you participate from that proceeding. I don't know how many judgments I've delivered on this point, but till date, nothing happens. Every time Order 9 Rule 7 has become a substantive provision by which to debar people to do.
For admission.
Yes.
Lordship, this matter was actually heard earlier.
This is against the granting of temporary injunction by the trial court, your lordship. Trial court has granted the injunction, your lordship, without consideration. The fact that there is no prima facie case, no discussion of balance of convenience as well as irreparable loss. And then,
What? You filed, you were supposed to file something. Did you file it?
Actually, by last order, your lordship,
That's fine.
You on the last occasion said na he did not bring many materials.
That was filed by appellant side itself. As per order dated,
You only said all materials are not there, therefore, yeah, yeah.
and we have filed it, your lordship. And we have also filed.
Now, what is it? What is, where's the injunction order?
Injunction order at page 123, your lordship.
Page
115.
121,
121. Injunction granted.
exactly 120, your lordship.
In consideration, where the court established the three bewildered that is able to receive the remedy of Iman and pay. Yes, what is wrong?
So, your lordship, I have purchased the land, your lordship, by spending huge amount, your lordship, to the tune of rupees 91 lakhs. I purchased it from the recorded partners, owners and the position. And it is admitted, your lordship, by the other side, that my brother has actually transferred or sold the land to the present appellant before that, your lordship. Now she is claiming that she is a co-owner. Anyway, if you are co-owner, but that you are a co-owner from no revenue record which transpires. So if revenue record also
Is revenue record the basis?
but
Who was the owner actually?
actually from the records, I am the owner. That is my
No,
vendor.
very
is the
well,
owner.
you are the owner. You purchased from somebody.
No. My vendor is the owner. Your lordship,
Okay, very well. How does the vendor become the owner?
he became the owner, your lordship, by
How? Inherited. Who is he?
son.
He,
He is claiming to be daughter, your.
daughter. He is not entitled to.
No,
If it is an
we
inherited
are
property.
disputing, your lordship, that she is not daughter legally also.
Huh?
In our detailed statement, your lordship, we have disputed. Anyway,
No,
your
who are you to dispute?
No, your lordship, supposing your lordship,
Is the brother disputed?
there is no documentary proof that she is the daughter of so and so. But on the other hand, there is a sufficient proof that my vendor is the son of the original owner.
Understood. But the fact that whether he is the daughter or not, that is a question to be decided in the trial.
Supposing your lordship, even if she is the daughter also, your lordship, there are 3/4 and something lesser, your lordship, she is entitled to get only one.
Hmm.
And she is in position, that is B schedule land, your lordship.
Hmm.
Now, question is, your lordship, if she is in possession of the B schedule land, that is land measuring 1 kata and 6 lesser. Though she is entitled to get under the law only 1 kata and 1 lesser, your lordship.
Hmm.
On the other hand, her brother, he gets double. So if it is double, your lordship, it is more than 2 katas. Now here's the third test part, it is told, your lordship, only 1 kata 19 and half lesser. So from that angle also, your lordship, he is within the limit, he is having the saleable interest in respect of his 1 kata 19 lesser double.
How much is the suit land?
Lordship,
How much is the suit land?
Woodland is the 1 kata 19 lesser. Schedule A. Schedule A.
How much is the total land?
Total land is, your lordship, I am giving your lordship. Total
1
land
kata
is,
19 lakhs.
yes, your lordship.
Total land, what is this 3 kathas? Schedule D?
Total land is, your lordship, in schedule A and B, 3/4 14 and half less.
The father, your father had.
It is my mother's land.
So your mother had how much land?
It is, your lordship, in other schedules they have given, those schedules are not connected with the present suit, your lordship. This, according to the revenue record, it is 3/4 14.22 lesser.
It belongs to the
Belongs
mother.
to Mother, your lordship, that is the vendor's mother,
Okay.
my vendor's mother. If that is calculated that way also, she is entitled to 1/3, your lordship, I am entitled to 2/3, that is my vendor. From that angle also, your lordship, it is within limit of saleable interest. Our contention is, your lordship, there are some other properties, landed properties. And according to her, she is actually in possession of those properties. Because my vendor, your lordship,
You want to construct,
develop your lordship, correct, correct.
and if you tomorrow she wins the case, what will happen?
Definitely land will be her land, your lordship, and whatever structure stands there on your lordship.
You
Either
undertake to demolish it.
Either demolish or. if I
Even
say-
undertaking, I asked you to file,
Lot-
put it, isn't it? Didn't I ask you?
Lot.
You want to demolish it? Give a under.
Demolish or I can surrender also in their favor.
No. You are given undertaking that you, if the suit goes in against you, you will demolish it and hand over the possession.
Correct. Second land will be given to them, your lordship. If they win, if the plaintiff wins, your lordship, definitely they will get the second land, I will demolish it.
Given undertaking by filing an affidavit.
Before filing affidavit or not.
I didn't ask the same thing earlier.
Yes,
Correct.
You didn't file.
Correct.
Did you file?
Same. No, your lordship, that actually we.
I remember,
the law-
yes.
The order is not there that
Not necessary. Why should I?
before this court itself, your lord. Or before the trial court, your lord.
Okay, I'll put it in your words and I'll direct you to file an affidavit. The instant appeal has been filed challenging the order dated
23/2/2024.
23/2/2024 passed in Mirzay case number 1188/2023 entitled suit number 92/2023, whereby the learned trial court had passed an injunction order directing both the parties to maintain status quo in respect to the Schedule A and B plot of land till the suit is decided. Mr. S. Ali, the learned counsel appearing on behalf of the appellant, submits that the appellant had purchased the property from its vendor, who was the absolute owner of the suit land. He submits that there is no semblance of any right of the petitioner of the plaintiff over the land, or even in respect to the revenue records. The learned counsel further submits that in any eventuality, taking into account that the parties herein, the plaintiff as well as the brother of the plaintiff as well as the vendor of the plaintiff of the appellant belong to are governed by the Mohammedan laws. The share of the vendor of the appellant would be 2 kathas, more or less 2 kathas. And this is the
Above 2 lessons.
huh?
Little bit above 2 lessons.
Above 2 kathas, above 2 kathas. And this is the very portion of the land which have been sold to the appellant. And as such, under no circumstances, the learned trial court ought to have granted the injunction. Full stop. On the other hand, Mr. R. Ali, the learned counsel, clearly submits that the appellant, the plaintiff, is the daughter of
Ismat Ara Ahmed.
Srimati Ismat Ara Ahmed and late Ismat Ara Ahmed, and the defendant number 1, huh?
Yes,
Who's
I am defendant number 1. Only one defendant.
Huh?
2 defendants. Sole defendant.
Sole defendant, who? You.
Myself.
The defender,
defendant.
brother is not here in the suit.
He died already. Died. My vendor died, your lordship, brother died.
And the vendor and is the sole defendant too. Huh? Is the daughter of late Ismatara Begum Ahmed, and the vendor of the appellants herein was her brother. And as such, she had equal right to the suit land as described in the plaintiff.
Lordship, actually 5 plots are there. As per oral partition, 2 plots of land is the share of that sister.
Which are the plots?
Lordship will find at page number 24 of memo of appeal. Paragraph 4, I have explained to
No. Which are the plots which fell in you?
This is
Schedule A.
A and B.
And submitted that the schedule A and B plots of land fell into the share of the plaintiff pursuant to an oral partition.
Second list. 2nd January.
He therefore submits that any construction if carried out over the said land and creation of any third party during the pendency of the suit would not only affect the rights of the plaintiff, but also it would be difficult in the circumstance the suit is decided in favor of the plaintiff. Mr. S. Ali, rebutting to the said submission, submitted that the appellant, you are going to transfer?
Lordship,
Are you going to create third-party interest?
no, your lordship, there is no construction at all. This
No. Are you going to create third-party interest on the
It's up to the client, your lordship, in the long
Okay.
run.
submits that the
But I would develop your lordship.
no, develop is okay. Are you going to create third-party interest?
Loan, etc.
It may be kept by
If
himself.
mortgage the property, then it will create.
Anyway, your lordship, whatever it is subject to the result of the suit.
No, result of the suit, it can't happen like that. And it submits that any third party that the construction that the appellants have no difficulty in giving an undertaking before this court as to the effect that in the circumstance the construction so raised during the pendency of the suit is in the circumstance the suit is decreed and has no difficulty in giving an undertaking before this court that the appellant would be willing to demolish any construction made during the pendency of the suit. And hand over the possession to the plaintiff. In the circumstance, the plaintiff succeeds in the proceedings initiated. This court is of the opinion that such an undertaking, if it is to be given, has to be given by way of an affidavit and not by way of an oral submission. In addition to that, this court is also of the opinion that creation of third-party rights during the pendency of the suit may also have difficulty, for which the undertaking should also include that there shall be no creation of third-party rights during the pendency of the suit. Mr. S. Ali, the learned counsel, submits that he requires some time, so accordingly lists the matter again on the 2nd of July 2024. The appellant, if so advised, would be at liberty to file the reply affidavit and give an undertaking, else the instant appeal shall be taken up for disposal on the next.
Lordship, so undertaking in the form of affidavit.
Huh?
Affidavit in the
Yes.
form of-
Absolutely. Then it will be concrete.
Before this court, your lordship. Before this court.
Then only I can allow you. The issue which was involved here was as regards whether the notice is required or not. The BD Deka had stated about the rules, Rule 18 being now violative in view of the Land Grabbing Act. We have not gone into that issue. However, we have kept that issue open. It can be very well agitated at the appropriate stage. Now, on the question of wasteland, land, and land which have not been settled with estate of proprietor and all, there would be a legitimate expectation to that effect, both procedural and substantive, that they may have a right of settlement. More so when it is an unfettered discretion being given to the state in view of clause 14.3 and 14.4. So therefore, they would have a bona fide claim of right involved. And that would, however, be subject to they filing an application before the authority. Prior to that, there is an application filed. That is one. As regards the land, grazing land and all, they have no bona fide, they can have no bona fide right in respect of legitimate expectation for settlement. However, there may be a case where there might be a result of certain boundary that this land is actually not grazing, or this may be a case where there is a boundary dispute, or there might be a case where the land has been all along being settled, and thereupon the government may have made some mistake out there. Then also to form a subjective satisfaction without hearing that or without issuance of a notice would be in against the principles of our natural justice. So we say that although Radha Kanu states about that, about encroachers and all, but it does not deal with the question as to whether principles of natural justice is required, or for that matter, the last line of paragraph number 4 of the judgment categorically states that we are not dealing with the other portions of Rule 18. So that is not there. So this is what we have.
As regards my lord, adjudication?
No, that is not a part of us. That's not a part of our reference. Our reference was only as to whether a notice is required.
Your lordship has
And
held
we
no-
have relegated the matter back to the learned single judge to decide on what we have decided in this matter, because that is not for us to decide. We accordingly answer the reference holding that prior to initiation of proceedings under Rule 18.2 of the settlement rules, the occupant possessor of the government land have to be issued notice.
I make it clear that this order can be made online today, because there are many cases for under 18 to tomorrow pending. Can be done, we will place it before those under single judges.
Be done. It's otherwise it's already done, so you can get it. None appears on behalf of the appellant on call, but the matter has been taken up for hearing under Order 41, Rule 11. Accordingly, the instant appeal stands dismissed for non-prosecution.
Please, your lordship.
Second appeal, Lordship, and the substantial questions of either. The appeal memo.
Yes, what is your point? Substantial question of law.
The three substantial questions of the law we have framed, Lordship. Whether the impugned judgments are perverse in deciding the right title interest on the basis of sale deed dated 17/8/1978. Execution of
Where is the substantial question of law?
Lordship. The appeal memo.
Where?
There is a flag, Lordship, pink
Huh?
flag, pink flag, Lordship.
The jumper, you have, was in deciding the right title in interest.
Was denied by the executants. As much as the sale deed was
was only
executed from book.
But you see, did the vendors at all challenge the deed of sale?
Has not challenged it. In fact, in cross-examination, there are some contradiction also.
So what? Why should we look into it? We are in a second appeal.
Lordship, there is-
There is a case of the sale deed is of 1978.
Lordship,
30 years have gone by at the time when the suit was filed and
Okay.
when it was first produced. So the court need not go into those aspects. It is a discretionary power.
Lordship, in fact, Lordship, the plaintiff failed to prove his own case, Lordship, in my humble submission, Lordship.
How?
Lordship, in the plaint, Lordship, he has alleged that he put me in possession of the suit land in the year 2005. But the plaintiff's own PW3 and PW2 have said that I am possessing the land as per the gift deed given by my grandfather along with my grandmother. And since my birth, I am residing there. So I am possessing the land on the basis of gift deed given by gift
Who are you?
given-
You are the defendant.
I am the defendant.
And
He filed a suit in the year 2014 saying that in the year 2005, he purchased the 1 bigha of land from one Ishaq Ali by a registered sale deed. His sale deed is dated 17/8/1978.
who? The plaintiff.
The plaintiff purchased this land in the year 1978 and thereafter he mutated the land in the year 1980. Thereafter he said that I am a relative of the plaintiff and in the year 2005 he put me in possession of a 1 katha of land. So, and it was a condition that I will vacate the land as per his requirements. But in the year 2014, I refused to vacate it. So therefore, he filed this suit for the decree of eviction and delivery of khas possession. I appeared, Lordship, and I filed my written statement. I said that the land belongs to one Kamaruddin Sheikh, who is my grandfather, and during his lifetime, he gifted me 2 katha of land. So I am holding the land as per the gift given by oral. It was an oral gift. Yes, and I am holding
Gifted the land orally.
orally
Delivery of possession.
delivery of possession
And when was the deed of gift? Prior to 78.
prior to 70.
Was your age?
Age it was 11 years old. Lordship.
And how did you prove it?
So Lordship, then I said that it was my it
How
was a
did you prove it?
Lordship.
The oral.
None
You have
of
to
the
prove it.
none of the witnesses was there, Lordship. But
Okay. Try your luck after vacation.
Lordship.
This is the matter after vacation. Not 14. Yes, Mr. Taluga,
Lordship,
let us have it after vacation.
let's see.
Huh?
Let's see.
What is this
Lordship,
miscase?
One substantial question.
Section
on law,
5.
Additionally, I have submitted, Lordship.
Section 5.
Lordship.
What was the order?
Order is that, Lordship. I'm just,
What is the impugn order?
impugn order, Lordship may kindly see at page 12. Actually, on the point of limitation, the misapplication was rejected and therefore
How
Lordship,
much is the delay?
delay said to be Lordship 657 days. But Lordship, on that occasion, your Lordship was pleased to point out that the COVID vacation. So it comes to Lordship, if I calculate it properly, then Lordship, it comes to 348 days actual delay.
What is your explanation after 28 to 28-3?
Lordship, basically is
28-3,
that
19, this is an appeal against the year, it will be before,
appeal,
yeah,
Lordship.
so it will be 28-3, 2022.
That's it.
What is your explanation thereafter?
Explanation, Lordship, we did not get any information about the decree. We were unaware. What happened, Lordship, my employee who was looking after, he has left the job without intimation. What he did in the case, that was also not intimated. That is the reason why the applicant firm, appellant firm has not been able to file the appeal, Lordship. That is what is the thing. In one day, they got the, so there is, otherwise the copy time also cannot be excluded because, Lordship, that was not there. On a single day, the copy was received, Lordship. So it was 348 days because of, Lordship, ignorance. But however, one thing is clear, Lordship, to be candid enough, Lordship,
When was the judgment passed?
original judgment, Lordship, I am coming.
Twenty-one.
Yes,
27/4/2021.
27/4/21.
So you had time to file till 28-3.
Yes, Lordship. Because of
After-
non-information, Lordship, because of that employee had left. In fact, the firm now suspects collusion.
There is your application for condonation.
Application for condonation, Lordship.
What is your explanation?
At page 18, Lordship. Before the appellate court, Lordship.
How did it pass ex parte? Did you participate in the trial?
Expertise means expertise hearing order was there because I could not file the WS within 90 days. That is the reason why we were not allowed to file. Thereafter, what happened, Lordship? The appellant before your Lordship was not aware of these things.
Why?
Because he had left. Because he is the only person here, the headquarter is at Hyderabad, Lordship.
But understood, but where is the explanation out here in your application?
Application,
It's bereft of anything. Doesn't say anything.
no,
How
Lordship,
does this
the,
court
the,
interfere?
the time of, at the immediately on receipt of information, on having information, I applied for the
No,
certificate.
it can't be an ex parte because you had duly participated in the trial.
Participation,
If you
Lordship.
have participated in the trial and thereafter it has gone ex parte, whatever may be, you should have filed then an application under Order 9 Rule 13.
That was not done, dear Lordship.
Then
After,
the file and like it, because
I-
any portion of it will become it will be an ex parte.
I understand, Lordship.
It have been Order 9 Rule 13 and Order 9 Rule 13 or an appeal there against an ex parte judgment. Now, how do I help you with page 18A, the explanation given? There's nothing. You
There
say
is
that we
otherwise
don't
nothing.
know.
Only
Can
lack of
it be
information.
said that you can't know, you don't know?
On record, Lordship, I cannot say that I don't know. That is true. But factually, Lordship, what happens?
Now, what is wrong with the trial court judgment?
Trial court judgment, Lordship, the seller has no title over that particular plot of land.
You can't go on the defense, you don't have a written statement.
You don't. That is
So
the reason-
without defense, you have to therefore point out the falsity of the case of the plaintiff. Can you do so?
Lordship, what
I pray before your lordship is that I have taken shelter. If I am given little bit of mercy just to take.
No, no, mercy is not there. Mercy I don't
In
have.
that sense, no, no,
Mercy is
that
there.
that is in one sense. That is in one sense, lordship.
The mercy is there. Not here.
That is there. Lordship, what happens? If I am saved from being non-suited, lordship, if the case is
No,
remanded.
there are a lot of problems with you which you have.
Yes,
First,
lordship.
you don't have a written statement. Without a written
For the
statement, one has to
second
say,
I don't have anything to say on record, lordship. That is true.
then how do I help you? On it, under,
Whatever is-
I could have also framed another aspect of the matter on the limitation aspect. But limitation also, you have not stated anything.
At that point of time, the knowledge, only knowledge, lordship.
Nothing. Page 18A of your memo of appeal is nothing. Therefore, I said, let it be next week after vacation. Why do you want a dismissal today?
That is
Yeah.
only same, lordship. If at least if it is remanded, I am not arguing, lordship.
No, how do I remand you? I have to hold that the court is wrong. Then people will lose
But
faith.
even if expertise, lordship, the learned trial court ought to have passed the decree on merit. Because merely because it is expertise, the title is to be considered on the part of the seller. Because, lordship, I am the prior purchaser. It is not part of this argument, lordship. I am the prior purchaser, but I have been still in.
Therefore,
possession.
you are to show me that there is something wrong, drastically wrong in that order on the basis of the evidence which was placed. You have to show me that. Show me that what is wrong in the trial court's order. I'll frame a substantial question.
Lordship, so far the grounds are concerned, I have stated, lordship. I have stated. Let the matter be fixed after vacation, lordship. On
Just find out that.
that, lordship.
Can you put a hole out there? Once it is whole, then I'll frame a substance. Once it is done, I'll remand.
Lordship.
Because this will amount to what happens when an appeal is dismissed. It becomes now confirmation of the error. So my substantial question of law has to be on the basis of this.
Grounds I have stated in the grounds,
Grounds has to be also on the basis you don't have a defense.
that is their lordship, but even then, even on the basis of plain lordship, whether there is any title the seller has while selling the property to some other person, that is the present respondent, that is to be there. The seller has not been able to hand over the possession so far. I am still in possession. I am a prior purchaser from the true owner of the land. That is the thing, lordship. Just crux is.
Understood. But how do you take care of the procedure? Anyway, Mr. Talukder, appearing on behalf of the appellant, seeks for an accommodation, list the matter immediately after the summer vacation. Kindly out, if you have any case, you can meet out.
15 of like lordship.
Yes.
It is a lordship. The second appeal challenging the impugn judgment and decree dated 7/5/2024 as per the learned additional district judge Hailakandi in title level 3 of 16, affirming the judgment and decree dated 2/2016 passed by the learned trial court, your lordship. Grounds are at page 5. Substantial questions of law at page 7.
What is the suit for?
Has been filed. Prayers are at page, your lordship. Page 54, your lordship, of the plaint.
This is a dispute between whom and whom?
The suit has been filed.
Who filed the suit?
Filed by the plaintiff respondent.
You are plaintiff?
I'm the defendant number 2, appellant.
Who? Yes. Yes. You are the person who took the money.
Yes. Our
Then-
fact of possession has been proved. Our fact of possession has been proved. Based on that, on acquisition, we have got a portion of the compensation that has been awarded, your lordship. So during the entire process,
So you mean to say that in view of the provisions of, this is under the National Highways Act,
Yes, your lordship.
so it will be under 3H4. The district judge would only have the jurisdiction, not by way of a suit.
Lordship, we have stated that before coming to the court, section 18 of the Land Acquisition Act is there, where if there is any dispute regarding apportionment or anything,
Aha, if it is done under the National Highway Act, why will you go to the Land Acquisition Act?
lordship,
Then,
that ground we have taken, your lordship.
and how does the trial court and the first appellate court look into that aspect?
Lordship,
34.
we have said that issue number 2 has not been decided regarding maintainability of the suit, your lordship.
You didn't raise it properly.
We have in our written statement stated, but the issue has not been properly decided. Page number 15 of the trial court judgment, your lordship.
Heard Ms. S. Dasgupta, the learned counsel, appearing on behalf of the appellant.
Defendant number
Mr. K. Bhachaji appears on behalf of
7, 8, 9, the state respondent.
7, 8, and 9. They're appearing for 10.
Yeah.
Mr. S. Dotto appears for respondent number 10. The instant appeal is directed against the judgment and decree dated 7th of May 2024, passed in title appeal number 3/2016, whereby the appeal filed was dismissed, thereby affirming to the judgment and decree passed by the learned civil judge Hailakande dated 2/2016, passed in title suit number 14/2012. The instant appeal is admitted on the following substantial question of law: whether the learned courts below were justified in decreeing the suit in favor of the plaintiffs in view of the provisions of Section 3H of the National Highway Act 1956. Issue notice, call for the record, steps within 3 days.
IA for stay,
What
IA for stay of the,
is the stay?
for the stay of the impugned judgment and decree of the learned appellate court, your lordship. IA
Issue notice
1610
করে দিব। Issue notice করে দিব, reported on 9th August. I cannot no issue notice. We'll see later on. Have they filed execution? No,
not yet.
we'll see.
Number 37, stay with us.
Yes, Mr. Sahu.
For transfer of
Item number 17.
17, 37, stay matter.
17, what is that?
17 yet to come.
Why you is asking for adjournment?
No time.
Who asked for adjournment today? Item number 17.
17, Also, they are sitting, nobody.
It is not, isn't that Pathard matter?
Yes, my lord, that.
Yes, then why somebody was asking for adjournment? You asked.
No, no.
Somebody was mentioning the matter in the morning. I said it's a Pathard matter. Somebody without the gown. Yes, where is that person?
That is for 11, item number 11.
No, 17. No? 17 morning, the person who was wearing the gown in the court.
On whose behalf? My lord? I asked him, your lordship, for which number you have told, he said 11.
No.
I was sitting there. I am
Ah.
not.
No, he mentioned about 17. I said nothing doing. Huh? He made a wrong mention. I said it's a Pathard matter, nothing doing. Anyways. Huh? He was wearing a gown out here before mentioning. See his audacity. Yes, what do you want?
Because in this case, the respondent is
You
avoiding
served it. You want to transfer from where to where?
from Borpeta to Nalbari.
Why?
On the
You are a
ground.
young man,
Section
young
19.
woman.
No, I'm, yes.
Then
Section 19, my lord. The jurisdiction doesn't fall there, my lord.
why? Where's the other side?
He's avoiding service, my lord,
Why is he avoiding service?
because he's CRP personnel working at Jammu and Kashmir.
Then
But he has notice of the case because his case has been stayed, my lord.
service has been given on affect the service.
No, the notice has not been served.
Hmm?
So notice has not been served. Answer notice has returned back.
Then you can't serve it to your husband.
Because he's working at Jammu and Kashmir.
He doesn't write letters to you.
My lord.
He does not write letters to you. Okay. Hello. The service being not complete. List the matter. He has given a phone number. Why didn't you call up? 8400744408. Effect Dusty Service.
Hello.
Mr. Taking into account that the service is yet to be completed upon the respondent, Mr. S. Sahu, the Learned Counsel is directed to effect Justice Service suited to the registry of this court. List the matter again on 9th of September 2024. Interim order passed earlier shall continue till then.
As well as through family court Borpeta, my lord.
Family court Borpeta means where? Family court. You have not been able to do it. Justice Service you try. Effect.
He's now in Assam right now.
Go, very well. Go and serve it. And file a affidavit of service. I'll transfer it. This is a case for transfer.
Yes. By the time I get these notices, my lord, if he goes back, then my lord,
Then take a flight to Jammu and Kashmir. Yes. At the cost of your client. Yeah, anyways, holidays are there.
or otherwise, my lord, he's both ways, my lord. Dusty as well as through his official address, my lord.
We'll see later on. First, effect Dusty.
Obliged.
What are these?
Revision petitions, my lord, out of the same proceeding. One is, my lord, this 102 of 2023.
What order?
There we filed a petition for amendment of our plain, my lord. That was rejected.
Amendment of your plaint was rejected. And why is the other one?
Other one is, my lord, my status quo order was there during pendency of the suit. The day when it was posted for passing necessary order, the presiding officer was not there. So immediately it was posted next day. That day could not appear, so status quo order was vacated. Perhaps relying on that resurfacing judgment, the stay order will be vacated if it is not intimated. But there was a stay order by this honorable court on the revision petition, which we have produced before the court. And
What
accordingly,
is your application? Let
Your
us see what is your
application, your lordship will
application
find at
rejected.
page
Why?
148.
Amendment of the plaint.
Yes, my lord.
Page?
Page 148. The amendment paragraph is, my lord, is at page 150.
Why was it rejected?
Was rejected, my lord, because we alleged some violation of the status quo order during pendency of the suit.
Oh.
But the learned court came to a finding that
Where is
here
that
was
order?
page 208. According portion, the third paragraph. We alleged status quo violation.
How many applications have you enclosed here?
There was
Something like that, yes. Registered an application and no, what is this?
The learned court,
I peruse that there are multiplicity of defendant file stating the proponents shall change the nature and character. Further content, the defendant has never debarred from using and enjoying the suit land. The file under consultation has made no allegation that the OP has created in third party area. On the contrary, created thus I have considered that there is no violation and right? What is wrong with the judge? Yes, Mr. Nandi,
My lord,
what type of orders are these?
this is the first, they preferred a suit and then injunction petition. In the injunction petition, the order is given that the defendant should not create any lease in favor of any third party. We have not created any lease in favor of any third party. We are, after the construction of the ground floor one room, we have started our, this thing, cycle show. Here, this, when we have, this thing.
You are the
we have-
defendant
I am the defendant here.
and he is the
He is
plaintiff.
the plaintiff.
What is your claim?
we filed a suit for a specific purpose of an oral agreement, my lord.
Fantastic. Now, he wants to include what? The statement out here to the
My
effect
lord.
that there is a status quo violation.
Violation.
Status quo violation where I have violated. That is that the status quo order is specific regarding I shall not create any third party this thing lease, or I shall not let out the premises to in favor of any third party. I have not done that.
So, Mr. Nandi, if this is inserted, how does it matter?
My lord, kindly peruse.
No, what, you are good.
Your honor, it is
This-
changing the, there from this thing, from the
His case is for specific performance.
specific performance of oral contract.
Very well.
There was
Declaration the
never,
defendant
we
has
have
no
in
right
our
whatsoever
written
to use and
statement,
occupy any part of the scheduled building for their personal or commercial use, or to create any third party interest thereon by way of a lease, tenancy, so and so. A permanent mandatory injunction directed the defendants to close their. Why you are asking these reliefs?
My lord, there was an agreement, the specific plea I have taken in the suit.
Now,
my
is
lord.
the agreement say that he cannot open a shop?
No.
Then
As per the agreement, we have a specific plea, my lord, that building would be handed over to us, my lord. We are the.
Oral,
tenants.
oral.
Oral agreement. This is
oral,
yet to be
very
proved,
well,
my lord.
that will be proved.
It is the subject matter of
Yeah,
the suit, my lord.
suit.
So far as amendment is concerned, this is
Amendment is concerned, why you are asking A1 and A2 prayer?
the subsequent events. my
How
lord,
does
the-
it have any relevance to your suit for specific performance?
my lord, if he is in possession of the, my lord, the premises, my lord, I will be.
He is already in premises.
I am already in premises.
Yes, my lord.
There is nothing.
There is no quarrel that he is not in premises.
There is no quarrel. This
Then-
is an admitted position, well, after construction.
How does it matter?
Correct.
Why you are into A1 and A2?
My suit, my lord, the relief I paid in the suit will become infructuous because, my lord, there is a relief that there is an oral agreement between us, by which, my lord, I have invested the lakhs of.
What is
amount.
your prayer in the suit?
This is totally going to change the nature and character of this suit very soon.
It
A
won't.
specific performance of page 23. Directing the defendants to complete the remaining part of construction of suit building and let out the entire suit building to the plaintiff as a.
So you are in occupation.
I am in occupation, my lord. When I was in occupation on the land, my lord, there was an agreement by virtue of that agreement, my lord, a Assam type house was constructed. And there, my lord, I am aparting my business. As per the agreement, my lord, I have invested the entire amount for the construction of the building, and the agreement says, my lord, as per the oral agreement, which is yet to be proved. As per the agreement, my lord, the entire 2 stories building would be handed over to me as a tenant. But in the meantime, after the status quo order was passed by the learned trial court, he inducted himself as a, my lord, tenant here, and now
He inducted himself
himself, my lord.
as a tenant.
As a tenant, my lord, he is occupying the building now, my lord. Tenant would be wrong, my lord. He is occupying the building, and now he is operating a.
Was he not in possession at the time of
No.
filing of the suit?
No, my lord. The building is, my lord, is a newly constructed building.
Understood. Was he not in possession of the suit?
No, my lord.
Who
Because
was in possession?
I was operating a business.
You were operating prior to that. Then he started constructing.
He started construction.
So at that time, who was constructing? He was in possession.
The construction was not completed at that point of time.
Maybe, but were you in possession of the half-constructed building?
I was given a, my lord, Assam type constructed house, my lord, constructed by him temporarily to run my business.
So are you still there?
I am still there.
So how does it matter then?
Well, this is not the condition, my lord. This is the entire suit. My lord.
Mr. Vishwas, I don't appreciate the order passed by the learned trial court. It is wrong. But then also, if I am under 227, what is all these things? You should stick yourself to what you are asking. How does it change your nature and character? You are asking for grant of specific performance in respect of the A plus 2.
We want to file a mandatory injunction petition. Well, if it is rejected, that's, my lord. On merit, there is no issue, my lord.
You file a mandatory injunction petition, you can very well ask for.
No, my lord. Unless and until these prayers are amended, my lord. The reliefs, my lord, I sought for, my lord, it's amended, and the pleadings
That
are
is the
amended.
biggest problem. There is one judgment given by the court out here, and everybody goes into that. 97 2 SCC 2 GLR page 727. That is the biggest problem. That has been given on the basis of that other judgment of the Supreme Court on 93 3 SCC page 161. But that judgment of Supreme Court never says that. One line it has been given that if you don't ask for the permanent injunction in the main plaint, you cannot. Can you ask for a permanent injunction that during the pendency of the suit, don't disturb me? That's a case of a temporary injunction. Then
But otherwise, my lord, the prayer and the pleadings, I want to insert, my lord, it doesn't change the nature and character of the suit, my lord, because the entire.
why do you require mandatory injunction?
Unless and until he is out, my lord, I will not be able to enter the premises, and I will not able to operate my business. My business now is in a very dilapidated condition, my lord. The Assam Thai house, it's not, my lord, properly constructed. And it was the understanding.
No,
at
you
the-
already have it as per A, the prayer A at page 23. To complete the remaining part of the construction of the building and let out the entire building to the plaintiff as a monthly tenant by handing over the possession of the same under the terms and conditions of the agreement. So this is your specific prayer. Now, during the pendency, if he does anything, how does it matter? This is your final, this is your relief.
But the violating the status quo order, my lord, now he has started the business of cycle store, my lord. Now, in the meantime, my lord, if the building is constructed, in the meantime.
Then why you are not asking for an injunction that not to start any shop?
That's
What is
why-
all these things
that's why
asking for
this mandatory
amendment?
injunction. That's why, my lord, the prayer is for mandatory injunction, my lord, I want to insert. So that, my lord, rightly or wrongly, my lord, if the learned trial court, my lord, rejects, my lord, that's a different issue, my lord. But so far as this contention is concerned, my lord, it doesn't change the nature and character of the suit.
It does not change. It is absolutely unnecessary. You see, it is not only question of nature and character, it is also essential for proper adjudication of the suit. It is also very relevant. Don't you think so?
Yes, my lord.
Sir?
But so far as the order
Anyways.
passed by the trial court is concerned, my
Sir,
lord, it has
We
taken into consideration.
dismiss your petition on that. Although this court is not perhaps to the view taken by the learned trial court. On the details, the sought for is not essential. However, I give you the leave that you want to file a suit, injunction, mandatory injunction as well as he shall be permitted. Just waiting for one order, some matter to come with that prayer thing. Change it, yes.
If I may praise the other aspect of the matter, my lord, the paragraphs, my lord, I want the subsequent development, my lord. It is essential, my lord.
I've seen the amendment. Those amendments have nothing to do.
The satisfaction of my lord.
Chalo, your suit. You want to get it stayed.
My lord,
Is it stayed or not?
it has been stayed, my lord.
Ah,
I want to
fantastic.
proceed with the suit, my lord.
Let it be stayed for another 5 years. Let us admit it.
My
What
lord,
is?
My lord, it is the
Yeah.
hardship is on me because the construction that I have undertaken,
Ah.
ground floor is my commercial. And first floor and second floor is the residential.
Ah.
I have categorically mentioned, and they are aware about this fact. And how the residential part can be given to them? It is their oral agreement. What type of oral agreement they have made?
This is yet to be proved, my lord.
I have already mentioned in my written statement, counter claim.
Anyways, let us have these after vacations.
And my lord, the other that
Is the matter, because I have very less time today. I'm rising early because of a reference.
My lord, just one prayer. This second petition,
Mr. Nandi, what do you want? These matters should be disposed of early?
as per the convenient of.
No, it would take only 10 minutes for disposal. It doesn't take much. This is a small matter. But what do you want? If you are aggrieved that the matter is delayed, I will dispose it of, not at his condition. Tell me.
My lord, just I want to make my submission on this point that this second that read petition.
Release the
it is
matter after
against the
vacation.
vacating injunction order. There is appeal lies. How the CRP can file? Anyway, let it be on the next date, madam.
It's the matter on 1st of August. 2nd of August.
Biplab.
Final disposal
Much of it.
at the admission stage. Patient stage.
There is a stay order in the item 30.
It is until further orders. Yes, madam.
My lordship, as per lordship order, we have communicated the same to the family court, my lord.
Then
And then on that day, the.
nobody has appeared.
No, here not in the High Court. They were absent on that day. Here we have.
Court duly
Here we
takes
have
note of
services from
the
we have-
order dated 24th. Judge Family Court.
First affidavit we have filed.
In the respondent. From where from it seemed that the respondent hearing did not appear on the date before the learned. As it may, it seems that the learned, yeah, but be that as it may. This court gives an additional opportunity for them to appear. Accordingly, list the matter again on 11th of September 2020. Interim order is there, na? Interim order passed earlier shall continue till then.
Must have left, madam, because there is another date on 31/7, we'll again try to convey. 31/7, there is another date of less.
Yes, what is this? None of the parties are
Plaintiff's
aware
versus
what is
plaintiff
the
or
application
amendment
under
of-
order 7, rule 7. Prepared to do so. Yes,
Amendment.
we are not prepared. Where is the other side? Yes, what is the stage in which the amendment,
SBPH, lordship, SBPH. In page 33.
what is the amendment sought for?
Lordship, I want to relinquish some portion of land from claiming share, lordship. The petitioners are the daughters of the owner of the land and lordship opposite party are the brothers, lordship.
And
So they are residing over a plot of land that I want to incorporate that portion may be lordship, we are relinquishing our prayer from that portion. Lordship. So after written statement, we came to know
there
that.
is your amendment application. That though the father of the parties have left another plot of the plaintiffs have abandoned the. That's the only amendment.
Yes, lordship.
Well, why was this not allowed? It is in fact not an amendment to
Amendment is
the
a
fact,
correction.
it is more like a order 23 rule
Yes,
1,
one correct.
abandonment of a part of the
Fine.
claim.
They have left some portion of land, then
So
they
let it
want
be
to
there in
inside
the
it.
pleadings, it's good.
It is good for
You are
us.
the plaintiff.
Plaintiff.
This is an application filed under Article 207 of the Constitution challenging the order dated 3/11/2023 passed in Midday case number 61/2022 arising out of title suit number 34/2020, whereby the application filed for amendment of the plaint was rejected. This court have duly taken note of the application filed under Order 6 Rule 17. And therefrom it is seen that that by way of an amendment, what the petitioners being the plaintiffs sought for is to abandon a part of the claim that is in respect to land measuring 2 bighas, 1 katha, 1 lechas covered by patta number 11, dag number 64, situated at village Bihtor, Sengamari under Revenue Circle, Dongta, bracket Bidyapur. Full stop. This court finds no in the opinion of this court, the initial application was more of an application under Order 23 Rule 1, thereby abandoning a part of the claim. And as such, the learned trial court was not justified in rejecting the said application, whereby the plaintiffs sought for abandoning a part of their claim in respect to the land aforementioned. Under such circumstances, this court interferes with the impugned order dated 3/11/2023 and allows the application under Order 6 Rule 17, which have been registered and numbered as Midday case number 61/2022. The learned is seen that this court, by an order dated 22/1/2024, had stayed the further proceedings of title suit number 34/2020. The said stay order stands vacated and the parties herein who are duly represented are directed to appear before the learned trial court on today is first. Today is 27, today is 27. No? On 12th of September to 12th of July 2024, on which date the plaintiffs shall file the amended plaint without fail, file the amended plaint. It is made clear that if the amended plaint is not filed on that date, the consequences as entailed under Order 6 Rule 18 shall follow.
Forty-two.
Yes, what is this?
Lordship, this is a matter where I was barred from filing my written statement since
Uh-huh.
90 days.
How many days?
90, it was on the 90th date that the.
4.5 months.
It was on the 90th date that the impugned order was passed, your lordship.
98 day,
98 day, your lordship,
5/2/2024.
your lordship, 19/12/2023, page 30.
Page
30.
30.
Yes, your lordship. This is the day when my prayer for another date was rejected and the case was filed for evidence.
Oh, Learned Counsel for Equity has stated due to lack of relevant evidence. So,
Thereafter, your lordship, on the next date fixed, your lordship, I went along with a written statement and along with a application under section 151 CRPC and also with an application in section 5 of Limitation Act, your lordship. That order, your lordship, will find from page 31, your lordship. My debt. Page 39, your lordship.
there's a stay.
Lordship.
There's a stay.
Yes, your lordship.
Okay. What is the property involved?
Your lordship, an ancestral property, your lordship. Your
Who are you?
I am the nephew of the plaintiff, your lordship.
Cost 10,000.
Lordship, maybe decreased.
Huh?
Maybe decreased a bit, your
Dismissed?
decreased, your lordship.
No, no.
Your lordship is a laborer, your lordship. Audit, they couldn't go from Guwahati to contest this, that's why delay was caused, your lordship.
Who?
The petition.
He has all the year to appear, and are you doing on the matter pro bono before this court? Then we not 10,000, we make it 15. 10, 5 for him and 10 for the Snehaloi. Make it 15, yeah. Okay. 15. Is an application filed under Article 227 of the Constitution, challenging the order dated 19/12/2023, passed in title suit number 26/2023 by the Court of the Civil Judge Junior Division, Kokrajhar, whereby the learned trial court had debarred the petitioner, who is the defendant in the suit, from filing the written statement on the ground that the 98th day had expired, on the ground that even on the 98th day, the written statement was not filed from the date of receipt of the summons. It is seen from the records that on 5/2/2024, there was an application filed by the petitioner under section 151 of the Code of Civil Procedure 1908 for acceptance of the written statement, and even a copy of the written statement was also, and leave was sought to file the written statement. However, the learned trial court, by the order of the same date, that is 5/2/2024, had rejected the said application under 151 and did not accept the written statement. The learned counsel, appearing on behalf of the petitioner, submits that on account of these difficulties beyond the control of the petitioner, the said written statement could not be filed on 19/12/2023. Third, the learned counsel is appearing behind the parties and taking into account the fact that the written statement is ready and was also placed before the learned trial court on 5/2/2024. This court, for the ends of justice, thinks that the petitioner herein with the defendant should be permitted to file the written statement. Accordingly, this court therefore interferes with the orders dated 19/12/2023 and 5/2/2024, and thereby directs the learned trial court, that is the Court of the Civil Judge Junior Division, Kokrajhar, to accept the written statement. Be that as it may, this court cannot also be unmindful of the fact that there is a period of limitation, where there is a period stipulated in other orders 8 Rule 1 of the Code of Civil Procedure, wherein it stipulated that the written statement has to be filed within 30 days, and the court cannot enlarge the period beyond 90 days. Under such circumstances, if some cost is not being imposed, it will show a wrong signal, and accordingly, this court imposes a cost of 15,000 upon the petitioner to be deposited on the next date, so to be filed on the next date as fixed by this court. This court taking into account that there is an order, this court taking into account that this court vacates the order dated 11/3/2024 passed by this court and direct and as the parties are duly represented, direct the parties to appear before the learned trial court on 15th of July 2024, on which date the amount of rupees 15,000 shall be deposited before the court, along with the written statement be filed. It is made clear that the deposit of this amount of rupees 15,000 shall be a condition precedent for acceptance of the written statement. The plaintiff would be at liberty to to file an appropriate application before the learned trial court for the purpose of release of the said amount, and upon such application being filed, the learned trial court shall pass appropriate orders. What? 20? Don't reduce one more. 10 going.
Oblige.
Yes, Mr. Sahu. We take this matter on some other date and hear it. But today is the last day, almost the last sessions. We have extended the interim order till the disposal, so there is there. You find did you find anything, Mr. Sahu?
Yes, my lord. 159(6). Actually, my lord, what it is 3 judges bench. 3 judges bench says that even if there is no limitation prescribed, but one has to come within a reasonable time. So from that point of view, I do not have any guess. But prior to 2019 amendment, there is a provision, 159 subsection 6, my lord, that speaks about filing of report. And 166(4) says that report can be treated as a.
Now what we are having now. In fact, now, after this amendment in 2019, you have the 3 R's, what you call the first is the DAR, IAR, investigation first report or something. There is a interlocutory report, and the final. Now the DAR, that is the detailed accident report, it is to be treated as a claim petition if a claim petition is not being filed. Claim petition is being filed, then the DAR it culminates with the claim petition. Therefore, now 166(3) is there. It stipulates 6 months. And the judgment of the Supreme Court in Ghaffar Ahmed also makes it very clear how it is to be done. There were certain things which. Anyways, we'll hear the matter for when. And you people are the busy people. I'm always here sitting. When?
Hey, dear.
Can we have it on 13th of August?
August.
13th? It is Ulasana. It's the matter on 13th of August 2024. Doing it as part of it. Yes, what is it?
I'm appearing for the respondent's lordship. LCR has been received and the matter is ready for hearing. It may be posted for hearing.
How is ready for hearing? 15.
18.
18 is how?
RS.
Ready for hearing?
LCR has been received.
Various applicants and have expired during the pendency of the incident and according various have been carried out. The Town Council on behalf of the applicant is like registry shall make necessary correction. Now everybody is alive.
Yes, Lord.
Is the matter for hearing? (28), 2024.
Obliged, Lord.
And appears on behalf of the applicant, list the matter after vacations. Everybody represented? List the matter. Service being complete and the LCR being received, list the matter for hearing in its usual course, liberty given for filing it earlier today.
Obliged. Highly obliged.
Application for condemnation or delay and substitution.
How much?
They have 178 days, the lot.
TRPIO? TRPIO is done under what provision?
Applications pending for substitution of the legal heirs.
Each one. Service is complete.
Service complete, Lord. As per the
Okay.
office, it's complete.
Service is complete, list the matter immediately after vacations. What is this, Mr. Sharma?
Condemnation delay, my lord.
How much?
In this petition, my lord, I have also filed a reply, my lord, a hearing reply. That reply.
How much is the delay?
Delay is substantial delay. my lord. It is, my lord, 10 years, about 10 years. What happened, my lord, in this case?
We'll have it after vacation. We don't have time now today. List the matter immediately after vacations. 23. Anyway, anybody has an interim order, otherwise all these matters will be given sent after vacations. Any interim orders to be extended? Is anybody appearing item number 28? 28? How much is the delay?
8 days. Notice is yet to be.
Service has been issued.
No, notice has not been issued.
Notice has not been issued. They took notice koribo. Notice itu and 6 weeks. Expiry has been. Condonation application. And what is 30? 30, who is appearing? You are there? Review petition 100.
30 is Pran Gopal.
Huh?
30 review petition, Lordship.
The review petition, they write whatever.
Item 30, Lordship. Yes, Lordship.
30 is a review petition.
30.
FZ Zaman.
Yes, Lordship. FN Jaman.
Ah.
My
But what is this review to?
CRP judgment was passed. I have missed this item, Lordship, today. After vacation.
What is wrong with the order?
Yes, it is stated that, Lordship, the suit has to be filed before Waqf Tribunal, and thereafter again our Lordship, the plaintiff defendants were directed to prefer a regular first appeal before the first appellate court, Lordship. Whether that judgment passed in the suit can be disposed of in a CRP, or we may be Lordship required to file a first appeal before the first appellate. That point, Lordship, I have filed the review, Lordship.
Okay. No, you say that the appeal lies before whom?
Lordship, in a suit, Lordship, suit was decreed, suit filed by the plaintiff and we are the defendants, Lordship. Said that it is a work of property, Lordship.
This is not my judgment. Will it go upon it? Madam, we issue notice because this will require notice. To notice steps by, yeah, returnable 6 weeks. Registered as will.
Keep your place.
Yes, Mr. Purkasta, you are waiting for which matter? Even after with the pain in your hand and all. Yes. Which matter?
Nothing more is to say, my lord.
Huh?
Only LCR has come.
Which one? Item
Item 31.
31. LCA has been received from Iman and has been. Why LCA called in CRPIO?
Because it is a matter of land grabbing case.
Land grabbing appeal.
Or land grabbing case? Okay. LCA has been received, then
Better be hard.
we fix it for admission on a non-miscellaneous day. Let's fix it on, what about 12th of September? Okay. Okay, I said 31. Heard Mr. A.K. Purkasta, the learned counsel appearing on behalf of, taking into account that the service is complete and the LCR has been received, list the matter on 12th of September 2024 for admission. An attempt shall be made to dispose of the matter on that date.
Value of this.
Obliged.